Allowed to mentioning a matter. A matter supposed to be come after puja vacation. Actually, the incident is occurred. A school teacher, high school teacher, allegedly,
What are you mentioning?
yes, my lord, his suspension should be considered. Actually, the ad hoc committee could not interfere.
Want the merits of the matter? Why are you mentioning? Is it for inclusion in the list?
My lord, after puja vacation, it should be come. Actually,
Yes, so puja vacation has gone, Christmas vacation has gone. Now
my lord,
you are coming.
urgency is that.
Urgency has cropped up now.
Yes, my lord. Actually, he is the
Next month.
physical education teacher, and
for this case.
Nothing, no inclusions. I have taken up all mentioning slips
my
on
lord,
Monday.
school want him. Actually, he's the teacher, physical education. Actually, my lord.
As appearing before your lordship's monthly list, my lord, but under the incorrect heading, my lord. I have mentioned the item numbers and the heading under which it should appear, my lord.
What is the incorrect heading?
My lord, it is one SLST matter, one transfer matter, and one pension matter. These are appearing under the heading others, my lord.
Doesn't
The
matter.
specific
Let it remain. It won't create any problem. Let it remain.
Lordship, I am mentioning one matter from monthly list 132
For
item
what?
number. Lordship, they have challenged they have appeared for petitioners have appeared for second SLST, and they have challenged the questions of biology 11 12, and the respondent authority have not replied yet. Lordship, their verification have already been done, and final list will be coming out shortly, Lordship.
Yes.
Lordship, if your Lordship can hear the matter urgently,
No,
Lordship.
not now.
My lord, few matters, my lord, I have mentioned one on Monday. My lord, that matter is, my lord, I have now segregated, my lord, is pending before the commission and pending before the DI. Few transfer matter, analogous matter. If your lordship kindly fixed,
No, you have handed over
but
the
not
slips.
segregated, my lord, some other matters are also there.
That doesn't matter. Let my officer do their work. Thereafter, I'll see.
My lord, under extreme emergency, my lord, may I be permitted, my lord, to mention this matter, my lord, it is in the combined monthly list, my lord, as item number 1986, my lord. My lord, the ground for urgency, my lord, is that the petitioner, being an assistant teacher, has been stopped from joining his duty without any notification.
Has been stopped from?
Joining his duty without any notification, without any opportunity of hearing, my lord. And my lord, from this month, his salary also stopped suddenly. My lord, if my lord grant me a hearing, my lord, I would
I accepted mentioning for upgradation on Monday. What were you doing? More than 200 matters have been upgraded and directed to be enlisted.
My lord, I apologize, my lord, I couldn't.
Please come next month. Yes, madam.
My lord, upgradation, my lordship.
No, please.
I had filed this writ petition under Group 2. Your lordship was of
Group 2?
Group 2.
Yes.
Your lordship was of the opinion that this is not a Group 2 matter. This should go under Group 6 because this is not education service matter.
All right.
My lord had released the matter,
Yes.
but my lord, I need your lordship's kind leave, my lord, to correct the presentation from Group 2 to Group 6. Otherwise, I cannot get it listed before the honorable.
But then when was the order passed?
19th November. Yesterday,
Now?
I went to no. I mentioned the matter immediately thereafter. Honorable court directed the matter to appear monthly list of December. Thereafter, I went to a department. But yesterday they called me and said that without your lordship's leave, they are not going to allow me to touch the presentation.
Yes.
Any date.
So what will happen? The matter has to be brought here in the list to be mentioned. Then order has to be passed.
Yes. Only that leave. Otherwise, I can. This
Give
is
the number.
pension matter. He has declared.
In this matter, I am filling form
Get
last year month. I have mentioned this matter for upgradation, but unfortunately not appear in the list. Matter appearing in the list, but not upgradation. Matter relating to CPF to GPF pension matter. Petitioner
Yes.
senior citizen.
Give the number. CPF to GPF. Bundle the other one.
Yes, madam.
Yes.
May I have your lordship's kind leave to mention item 161 of your lordship's monthly list, man. What has happened, man? The
I
petitioners.
just want to know what has happened. What you want?
The urgency, the upgradation, the urgency, my lord, is.
No, the upgradation 161 is pretty high. Why did you not mention on Monday? I'll take it up immediately. Please wait.
May I be allowed to mention
Yes.
to contempt matters for inclusion in the list?
I have taken up all matters. Not today.
Lordship,
The only thing, my lord.
contempt matters, Lordship, filed in December 2025, Lordship. Can it, if this can be listed in the monthly list of February at least?
Just wait.
The only thing.
Yes, call the list, please.
petitioners have
Original
been
site.
debarred from appearing in the interview in the second S.
আবার টাইম নেবে
Last
আবার লাস্ট চান্স তিনবার টাইম নিল
For this school,
Huh.
yeah,
What is-
getting service terminated by the school same is under challenge.
Well, the opinion oppositions, but the not.
Kindly says, but how many times he has taken time?
If it
Any
is in
third
opposition was to be circulated by 12th of December, We are in January. You have not taken steps. Please come. All three matters.
And I have lost my job, my lord, all three matters.
On the prayer of the learned advocate representing the school authority, time to file the affidavit in opposition stands peremptorily extended till 21st of January 2026. Reply within a week thereafter.
But today we are on 6th.
List on 3rd of February
3rd of February.
2026.
Grateful.
I think so.
Alright, in this matter, I am led by Mr. Kosta Bakshi. Although this matter was ought to appear on the 12th March 2026, but
We have
we
already
received
paid.
the notice at 2 a.m. and therefore, my lord, we could not obtain practically no information about whether
Lord, I have the instructions
Monday
that all the payments which my lord directed, those payments had been made and affidavit of compliance is ready. I am putting it.
Give it to him so that he can check it up.
He can get an instruction.
And I'll place the matter immediately in the list.
Because I understand that my
It is only for this reason that the order has been complied.
After reading the order today in the morning, I read this order. I said this was done because you did not comply with the order. You know, can you give that?
When do I keep it?
my lord,
Today is Wednesday. Friday I keep it.
my lord, at least give us 1 week time.
Why?
My lord, first we need to obtain the instruction, and then
Yes.
if there is anything, then we should be able to file.
All right. Give the compliance.
Yes.
Affidavit of compliance in all matters. It is there.
Yes, madam.
One by one. Is it serially? Item 1. লিখুন তো একটু। Affidavit of compliance filed in court today is taken on record. Who has affirmed it?
In respect of yes, madam.
Who has affirmed the affidavit?
Finance officer.
Acha.
Finance officer,
Of the Purulia municipality.
Salary was directed to me.
not an
Affidavit
executive
of
officer.
compliance affirmed by the finance officer,
Yes, madam. No,
Purulia municipality.
yes, madam.
Filed in court today is taken on record. Stop. Let copy of the same be handed over to the learned advocate representing the
Oh, okay.
petitioner.
Sankul got surgery.
Stop. Release the matter on today is 7th, then next Wednesday, 14th, I am keeping it. All right. Be open for the petitioner to file exception to the same prior to the adjourned date. If you have an exception, please serve prior
Yes, madam.
so that they also can take instruction.
Yes, madam.
All right.
Yes, madam.
And we learned only one indulgence.
Sudhir
The
Babu.
salary part,
1 week.
No,
kindly
no.
keep this relaxed.
He's suffering, my lord.
Who is suffering? Finance officer?
He then finance officer forwarded. He has taken over charge on 27th August.
Yes.
Finance and executive officer.
So what?
Yeah.
December? Only this petitioner is retired in 2017, not getting their dues, and the finance officer for 1 month, if his salary is not given,
He then finance officer forwarded, my lord.
whoever.
My lordship kindly consider.
Wait, consideration next day. Let them also suffer the consequences. They will not understand. They will understand when they retire and they do not get the salary, terminal dues.
My lord,
The
in
same
respect-
order will go down all one by one so that the affidavit of compliance can be taken on record.
I hope you can
Item
just
2.
copy the
আমি দিয়ে দিচ্ছি, সব দিয়ে
item
দিচ্ছি।
2 will be
দিয়েছি দীপক
আমাকে দিতে
তারপর
হবে
নাম
না,
হলো
আপনি
সুধীর
শুধু
বাবু
কমপ্লায়েন্স
item 2.
এগুলো রেখে দিন। হুম,
সুধীর বাবু নামটা পড়তে পারো সুধীর হয়ে গেছে তারপর পড়ে 5-এ কি আছে শঙ্কর
এই যে শঙ্কর, এই যে শঙ্কর। পাঁচশো নিরানব্বই, 599 তো ওটা।
নাম বলেছে তো শঙ্কর ডক্টর
3
সুধীর বাবু
হ্যাঁ 4
সুধীর পরে কি আছে আরো বড়।
all same
3 নম্বর কি আছে 3 কে শঙ্করী গোলমাল করো না ছুরি দিয়েছি হুম এবারে 6 দেখুন 6 কি আছে অফিস মেম্বার
অসিত এবার আছে মন্টু সেনগুপ্ত, মন্টু সেনগুপ্ত,
ঠিক আছে
মন্টু সেনগুপ্ত,
তারপরে কি আছে
মন্টু সেনগুপ্তর পরে আছে
চণ্ডীদাস
এই যে চণ্ডীদাস, এই যে চণ্ডীদাস।
অসিত মুখার্জি আইটেম নাম্বার 6 হ্যাঁ হ্যাঁ 7 মন্টু সেনগুপ্ত
মন্টু সেনগুপ্ত
8 চণ্ডীদাস চক্রবর্তী চণ্ডীদাস 9 ভূদেব মুখার্জি 9 10 কি আছে
10 হচ্ছে হিরো হিরো
হুম 10 হিরোদের পরে 11 হচ্ছে প্যারকাও দেখি
না এটা different, এখানে নেই।
কোথায় গেল 11 ঠিক আছে 12 কি আছে দিলীপ সেন
দিলীপ সেন, এইটা দিলীপ সেন,
দিলীপ সেন
দিলীপ সেন
13
13 এটা 13 all given.
In respect of item number 8, 10, 11, 12, there is no claim for area of pension, madam.
Whatever is there, let him see. The court is not getting anything.
Only
Do you get your professional bills on time?
Yes, let him also understand. Yeah, this is kindly do not take me amiss.
Yes, madam.
This is the reason why I do not appear on behalf of the statutory authority. And in one matter wherein there was a special engagement from the KMC, I told the KMC with the folded hands, kindly do not give me any brief. There are many lawyers, kindly give them the.
But you do some pro bono work also. You are quite senior.
The legal services authority is giving me the assignments.
Yes,
And
then
that
that's
is
all
being
right.
recommended by many honorable judges of this court.
All right. Yes, 14.
Get for it.
My lord, in item number 14, my lord, Mr. Shubhendu Bandyopadhyay is for a statement. But perhaps, my lord, we just file to a report, my lord, regarding this case. My lord,
And what has happened?
the report is yet to become, my lord.
Why?
Giving
On the last occasion also, accommodation was sought for on his behalf in December.
Yes,
Now
yes.
in January also same thing. Why?
my lord, last time, this is for last time, my lord.
Then I'll call for the authority.
My lord, only last time.
No.
Last order 9th December, my lord has been pleased to
Yes,
take.
9th of December.
But I am also, my lord, sent a letter to the, my lord, the board as well as the DI of school. This is the track report with me. They have received it.
I am appealing for secondary board, your lordship. Well, I have an instruction that we have received. This is group C.
My lord, will it be fixed at 12, my lord?
1 minute. Yes.
Yes, this is Group C, and we have received vacancies from the Commissioner of School Education, and we have already forwarded the same to the School Service Commission, my lord. We have received total
in the district of Purva Mendipur.
in the district of Purva Mendipur, we have received total 82 vacancies, out of which 72 vacancies have already been forwarded to School Service Commission.
All right, 72. Then 10 are still left.
That's not yet been sent. It will be sent within, because we have to go through a process. It will be sent because total 82 vacancies are there.
Is the petitioner's prayer?
Compassionate appointment.
Compassionate appointment.
Group C.
Yes. Then why isn't her name enlisted in the live register so that
well,
he can also
that
get a start?
that School Service Commission and DI may.
Whatever is to be done, if there are vacancy, then at least let her case be considered.
Whether her name has been forwarded by the DI to the Service Commission, my lord, that the DI can ascertain.
She has been found to be eligible for appointment. Even then, she is not getting anything. Is her name there in the panel for providing appointment? Everything is to be done by the DI.
DI is yet to be come, my lord. Is kindly fixed at 12 p.m. 12 p.m. my lord.
Why?
12 p.m.
It is already 11:13.
12, my lord. Report is yet to be come, my lord.
When will it come? Today?
Today, my lord.
Today? Very well, before rising in that case. Give a copy to him. Before rising. In the morning session, before rising, this matter will be taken up. Pass over. এটা আগের মামলার নোটিশ রেখে দিন. Yes.
Good.
Give a copy to him so that he gets to know what is there.
Appearing for the SSC.
Now, I don't have any grievance because
এই এটা চলছে না.
challenged by the school service commissions before the honorable division bench. Now this is the judgment.
Yes.
Now the division bench have allowed everyone and they agreed just 3 paragraphs. Kindly have a look at this.
Yes, so your grievance is redressed. Please come.
Yes.
The
He will be
judgment passed
appearing
by the
tomorrow
honorable
in the interview. my lord.
bench. On 16th of December 2025 in, take down the mat number.
My names are there also now interview list. So they are.
Stop. Learned senior counsel represent is placed before this court. ঠিক আছে, learned senior counsel representing the petitioners submits upon instruction that the grievance of the petitioners has already been redressed.
And they are already in the interview list also.
Stop. The petitioners are enlisted.
Yes.
In the in the interview list.
He has been asked to appear tomorrow to.
View of the above, there is no requirement of proceeding with the writ petition any further. Stop. The writ petition stands disposed of. Next.
My lord, I am for the petitioner. My
lord. 16, I beg to intervene because allegations has been made against me, but I have not.
my lord, no allegations.
Yes,
has been
absolutely.
made,
The
my lord.
petition, there are direct allegations.
Headmaster, board has taken certain action. I have challenged that order. My lord, they have complained against me. I have no grievance against them, my lord. And my grievance is against
No,
them.
my lord, school is an effective party.
School has been made as a
Oh,
party, my lord.
oh,
and
complainant,
has
yes.
also been made as a party.
My lord, may I
serve this school?
Yes, everybody served.
So far, my stand is concerned, Manad, I am one of the complainants. The
He
lady
also
teacher.
been transferred
Let
from
me
that.
hear what the matter is. I do not know. What is the complaint about?
Your lordship, my lord. In 2008, I was appointed as an headmaster. I worked there for 10 years, no problem. Certain teachers were constantly causing disturbance in the school. I, being the headmaster, raised complaint before the DI and the board and everybody, my lord. Based on my complaint, the board, my lord, directed the DI to cause an inquiry. Immediately after that, in 2019, the then local MLA of the ruling dispensation came to my school, threatened me. I did not withdraw my complaint. Immediately the next day, one of the assistant teacher lodged a complaint against me for under POCSO Act, my lord. I was
Also.
interesting. I was arrested within 2 days, my lord. The learned court granted me bail, making some observation that I wonder how such a case can even be registered. Immediately thereafter, my lord, I went to school. I joined. After 2 months, my lord, I was given a notice of suspension by the board. My lord, I was suspended, charge sheet was issued. I challenged both the suspension order and the charge sheet. Charge sheet was set aside by this honorable court. And my lord, liberty was given to issue afresh. After at least 1 year, my lord, next charge sheet was issued. In the meantime, my lord, the order of suspension was also before this court. This court, my lord, dismissed my petition on the ground that since the charge sheet has already been quashed, nothing remains. It was, but I prefer an appeal before the division bench since the school authority did not allow me to join, saying that the court did not permit me. The division bench thereafter directed the West Bengal board, you complete the disciplinary proceedings within 6 months. That was in 2023. And thereafter, if not, you will allow him to join. My lord, in 2023 order passed, no disciplinary proceedings was completed. I filed a writ petition saying that it was not completed. Allow me to join. This writ petition is before your lordship pending. My lord, during in that writ petition, the board filed a report that there have been 3 inquiries made by the board. All the 3 inquiries are inconclusive. I am a very influential person. I always influence the inquiry. Inquiry is not conclusive. This is the report which is filed before this court. Suddenly, my lord, the board in the month of November 2025 issued a notice that a complaint has been made, you appear. I gave a reply that kindly give me the details of the complaint, what complaint, and then I will appear. Thereafter, my lord, on December, the president of the West Bengal Board of Secondary Education, not the disciplinary, passed an order that you are do not appear, you did not appear, you are found guilty of the charges. So why you should not be punished for, you should not be terminated.
Malak, this is not the what she is
I'll hear
submitting
you.
is not
I'll
that.
hear you.
Kindly come to the order in
Show me the order where the court fixed a time frame for
My lord,
conclusion of the
division bench
disciplinary.
order is that page, my lord? 94. Relevant 97. My lord, paragraph 5, my lord.
Paragraph 5.
My lord, may I read?
Yes.
It is submitted that in view of the quashing of the charge sheet, the earlier order of suspension was invalid unless there is a fresh order of suspension by the board. We are unable to accept the said submission as the order of suspension passed in contemplation of disciplinary proceeding, and there was a technical defect for which the earlier charge sheet was quashed without interfering with the order of suspension. The order of suspension still remains. The disciplinary proceeding was
resurrected
by issuing a show cause notice in accordance with rules so of rules, and thereafter the explanation offered being found unsatisfactory and an inquiry officer was appointed. Under such circumstances, we do not find any reason to interfere with the orders challenge. On such consideration, both the appeals fail. However, we direct the inquiry officer to conclude the proceeding within a period of 6 months from the date of communication of this order by either of the parties, without granting any adjournment to either of the parties.
So that proceeding has been
1
concluded.
minute. In September 23, the order was passed.
Order was passed.
6 months time was given. It was not complete.
Not complete, my lord. Kindly report, my lord. Kindly have a. This is a report filed in this court, my lord.
এটা কোনটা কি রিপোর্ট
আগের মামলায় তোমরা যে রিপোর্ট
আমি তো আনিনি আগের মামলা রিপোর্টটা
Yes, yes.
No, it is on record, my lord. Kindly come to the, my lord. I will not take your lord. Kindly come to page, my lord, 6.
এটা আমার একটা কপি দে
Copy those.
আমার কাছে তো নেই
Yes.
My lord, I am reading this paragraph 13. I submit that the disciplinary authority of the board received the report of the inquiry officer dated so, which is inconclusive in nature. Hence, board could not conclude the proceedings within the time frame. Thereafter, board-wide memo dated so requested the district magistrate to hold further inquiry into the matter, and the report dated so of the said report was received by the board on Ato. As such, disciplinary authority of the board was unable to conclude the proceedings within the time frame as directed by the honorable court. My lord, after this, your lordship kindly come to page 116 of my writ petition. My lord, this is the report. Inquiry committee not concluded. This petition is still pending. My lord, page 116.
Yes.
My lord, kindly see the notice. Though it is not dated, my lord, no date has been given. 116.
Yes.
My lord, this is 113 rather, my lord. I am sorry, 113.
113.
113.
Hmm.
I am directed to inform you that a date of hearing has been fixed to consider the complaint against Mr. Ashik Iqbal Mondol, suspended headmaster of Modongram Swanso School. You are requested to appear on the scheduled date. My lord, this is the notice. Nothing mentioned what complaint, everything.
The precedent. This is not to the. This is the contribution. This is the conclusion of the proceeding. This is not a new complaint. This is the conclusion of the proceeding.
Wait, I'll hear you. Yes.
My lord, thereafter I gave a reply, my lord, to this. Page 119.
Hmm. Yes.
My lord, I say that I so have received so notice with the complaints. It is next page. It is critical to state in this regard that I have not received any photocopy of the aforesaid complaint or the relevant documents connection with the aforesaid hearing. This is for your information, record and reference. My lord, this I give. Thereafter, my lord, next page, page 120.
Forwarding letter to 122.
My lord, 120 is the forwarding letter of the Deputy Secretary Disciplinary Authority. My lord, kindly note. Disciplinary authority is issuing this forwarding letter, and my lord, the order I am telling you, lordship, is at page 122. My lord, please allow me to place the order, my lord, from page 123.
All right.
My lord, I am reading from serial number 1. What are the charges? He created an unhealthy and fearful atmosphere in the school during his tenure. He harassed 2 assistant teachers, namely so and so. He ran the school in autocratic manner. He made disgraceful comments in social media. He sexually harassed children. He was running another school by the name of Iqbal Academy. He did not deposit the full amount of money in the school bank account. It is reported that he was arrested on so and released on so. Finally, the DI of school, Barakpur, was appointed as inquiry authority, and the president of the school was appointed as the presiding officer. The DI was issued 3 reminders for submission of IA inquiry report in March, August, and December, and finally the report was submitted in December. The IA was not inconclusive, was inconclusive in nature, and the inquiry officer found the place of inquiry fearful and intimidating. Thereafter, the district magistrate so was requested in April to initiate a free and fair administrative inquiry regarding the case to arrive at a logical conclusion. And another letter was sent in August 2024 with a request to expedite the matter. The district education officer requested the subdivisional officer to cause inquiry regarding the matter. The subdivisional officer so formed a 3-member committee to conduct a hearing cum inspection regarding the case, and the said hearing was scheduled by the district magistrate in the office chamber. Finally, the subdivisional officer submitted the inquiry report in the district education officer, who forwarded the same to the board. There was no specific opinion or observation in the report regarding the allegation against Mr. Iqbal. However, the 3-member committee recommended to take necessary action against Mr. Mondol and repeated that 3 FIRs have been lodged against him for child abuse, financial complaint, forgery, and other charges. My lord, thereafter the 3 FIRs, I am not reading, my lord.
No, it is important. 3 FIRs.
All 3 FIRs against Mr. are sub judice at present, as informed by the DI of school. The matter was duly considered, and the president of the board was pleased to fix the hearing of the case on Ato. My lord, this notice, president of the board, my lord, with deepest of respect, your lordship knows, is not the disciplinary authority. The president of, you cannot initiate a disciplinary proceeding appoint a disciplinary authority being the deputy secretary, and the president will conduct a hearing and pass an order? Cannot, my lord, in law. Thereafter, my lord, what the president of the managing committee is saying, the following, my lord, the findings. The following reveal that from the submission of all parties and available papers in the file, there was no representative present from the office of the DI. Mr. Ashif Iqbal was also absent on the date of hearing, and he could not be reached over phone also. However, he sent a letter dated so. So my letter was considered, my lord, in which he has confirmed the receipt of the letter sent to him informing the date, time, and place of hearing. The suspended headmaster stated in this letter that he has not received any photocopy of the complaint and relevant documents in connection with which this hearing has been called. Although charge sheet has already been issued against him and he has replied to issue accordingly. My lord, your lordship knows the rule says inquiry report has also to be submitted, examination, cross-examination opportunity to be given. The present ATs and two ex-ATs were absent at the date of hearing. The president of the school managing committee has submitted orally and also in writing on the date of hearing stating the following. The president of the SNC assumed charge on 21 to 25 and he does not know the details of the internal administration of the school at the time when Mr. Mondal was suspended since he was not the president. The present complaint was lodged against the headmaster by some teaching and non-teaching staff. But there has been no discussion in the managing committee about the headmaster since his suspension of charge as the president. In fact, he is not aware of any such complaint being a resident of the locality. The president has no objection if Mr. Mondal resume his service in school as the headmaster, since the headmaster is required for overall development of the school. Now, my lord, the order I am coming, the order portion. Directly.
Oh, I will read 5 also. 125 at the
Yes,
top.
125 I'm reading. Sri Anushree Banerjee, she is the main
One of complainants. It's
My lord,
written.
now she has been transferred to another school. One of the complainant ex-AT and now transferred to another school has made her submission both orally and in writing on the date of hearing, which states the following. The case has been stated briefly in chronological fashion, leading to the point where she claims that the inquiry both by the DI of school Barakpur and the SC Barakpur 24 North on Atoyan was heavily interfered with by Mr. Mondal, which has been supported by observation of the inquiry officer that the place of inquiry was not favorable for conduct of inquiry in a peaceful atmosphere. Finally, the said inquiry was conducted by the office of the district magistrate and the 3-member committee was constituted for this purpose who submitted its report. Srimati Banerjee has said that Mr. Mondal has failed to produce suitable documents to prove his innocence in connection with all the charges. Further, regarding charges 7 and 8, 3 criminal cases have been filed against him. Charge sheets have been filed. The depositions of the victim, students' witness have been recorded before the learned judicial magistrate, and he is facing trial. He was in custody in connection with one of these cases in which the POCSO Act has been invoked. The present TIC of the school at T3, there was a crowd gathering on the date of hearing on Atho in the present premises where the inquiry was to be concluded. My lord, the submission of the inquiry authority and the Anushree Banerjee is different. Mr. Swanso ex-AT now transferred stated about the aggressive behavior of Mr. Mondal and confirmed that all the administrative statement when it was true. Now the order. Perused all materials on record and ends of the opinion, all the charges against Mr. Iqbal Mondal, suspended headmaster of the school, are grave in nature, and his presence in the school is detrimental for the overall environment of the institution. Hence, the undersigned empowered by the Swans of the inquiry conducted herein direct Mr. Iqbal Mondal to show cause why the following penalty will not be imposed upon him. Compulsory retirement with appropriate rate of pensionary benefit. Now, where is the inquiry? Where is the proceeding? Complete go by. Not I'm being late.
Yes. The initial complaint which was made against you.
Not served.
Not served?
No. Inquiry officer.
Charge sheet is something.
Charge sheet is something else.
Not
Complaint.
No, that was my first point taken. That's please give me the copy. Now this is recorded. They did not appear. He said that copy was not served. I'm a disciplinary inquiry in this way.
And copy is not served.
No.
This is your
85 पे
submission.
Kindly come to the. I just show you the relevant portion. Kindly come to page 124, para 2.
No, he has read out.
Yes.
Your junior has read out
Where
the
is
whole
the
thing.
My lord, page
disciplinary
85.
first-
My lord, he have annexed the complaint, my lord, that's page 85. My lord, kindly see. This is the complaint. He have annexed it at page 85. Kindly see. My lord, it is not only the complaint of
I'll hear you. Please wait.
kindly
This is
page
not the-
85.
This is not
Please
the
wait.
complaint, madam.
This is the complaint.
This is the initial complaint.
I have 2 points, well, a very important legal issue. First of all, I say the entire proceeding is malafide based on without some considerations which will be apparent. When I complained before the authority against 2 teachers, a local MLA intervened. He wanted that I should withdraw this. I did not withdraw POXO. And Lordship has seen the observation of the POXO court.
No, that I have not. That has not been
Kindly
fixed.
come to me, Lord, the page 51. And the PP's argument, if there is no POXO, there must be molestation. And that is also severely criticized by the London District Judge at page 51.
Yes.
But may I read it loudly?
Mm-hmm.
London Special PP, after going through the record case diary, admitted that POXO Act does not fit to come into force in this case, but submitted that there is ingredient of allegation of abuse and maltreatment upon children and female teachers. The female teachers, my lord, therefore, they were on the scene. On perusal of the record, case diary and recorded statement of the victim under section 164 in particular, I do not find any substantial incriminating material to come within the purview of section either 354 or 8 of POXO Act. I am struck with the wonder as to how a school's internal bickering and or administrative control could be a subject matter of POXO case.
The FIR appears to be vague and misconceived.
Well, page
view of-
50.
In view of the above submission and advocates for the accused and above all so and so, he was granted immediately bail. Then kindly come to me, Lord, when I lodge a complaint that these teachers are not taking classes, not maintaining the discipline, kindly turn to me, Lord, page 54. Lord, the Deputy Director, School Education,
Yes.
writes me in enclosing copy of complaint of Mr. Ashik Mondol, that is the petitioner. Headmaster of the school, which speaks for itself, he requested to inquire into the matter and submit a detailed report regarding taking necessary action as deemed fit to resolve the issues as mentioned above so and so. This remained unattended in spite of the deputy director's complaint. Now, immediately I am suspended. Page 55. That this is the deputy director's letter of 23rd September 2019, asking the DI to do that, and I am suspended on 4th December 19. Charge sheet was issued. This court found that the charge sheet is not maintainable, was pleased to be not set aside. Ultimately, the division bench said very well, let them issue fresh charge sheet and complete within 8 weeks. 6 months. 6 months, sorry. Now, it's the interesting part, my lord will see at page 124, there was no representative present from the office of DI.
Yes, I've seen that.
You have noticed that? Then about Ashik Iqbal, I said that I did not receive the copy.
All right. Is the state represented?
X80.
You are for the state. All right.
Well, may I submit one thing?
Yes.
The order, my learned senior friend showed, page 51, that POXO is not. Sir, आपने बोला? हाँ, बोलिए, sir.
Now, that in the matter pending before the copy. Here, the board says that the inquiry is not done.
No,
All right.
it says lot of other
But
things
then,
also. That is not with me. I
whether
cannot produce.
inquiry done or not is different. But did you receive a complaint? You did not receive the complaint,
That is
pursuant to which the inquiry is being conducted.
Yes.
That is
the latest
enclosed.
inquiry which is conducted pursuant to complaint which is mentioned there is not served on us.
Well, there is no
Whether-
latest complaint.
Will you please stop?
Lordship.
I'll hear you. It's not that I will not hear you. It's only the petitioner making submission.
Lordship.
The Was any further complaint, earlier complaint or anything, some like?
Nothing disclosed.
Never.
Nothing disclosed. Kindly come to page 113.
113, 4th of November 25 is
Yes.
the date of hearing,
Yes.
right?
And the undated letter.
Undated letter.
There you say, I am directed to inform you that a date of hearing has been fixed to consider the complaint against Asik Iqbal, suspended headmaster. Which complaint?
Was any earlier complaint served upon you?
Because that was the page 84 which she is referring to. 84 बोले ना?
85 sir.
84 is 83, 84 is a charge sheet.
That's the only thing.
No, 85.
The charge sheet.
No.
Charge sheet is by the board. Where is the complaint of
85? 85. 85. Kindly see, that is the complaint. That has been annexed with the charge sheet, and it is with the petitioner. Because with the charge sheet, all complaints and everything has been annexed, and he has replied to the charge sheet.
He has annexed this document.
This is his. He has annexed this, my lord. Page 85, and the complaint is. You kindly see the date of the complaint.
Now, may I read the charge?
July 2019.
What is the charges, Lord? Whether these charges would come within the misconduct and prescribed by statute.
That is different.
Yes.
But then whether it was served upon you.
Well, he has annexed, my lord.
Page 83.
85.
It is addressed to two persons, or is it the same person?
Same person. Asik Iqbal Mundal. This is a charge sheet. And along with the charge sheet, all documents have been given to him. That is the reason, my lord, we have annexed the complaint. This is the initial complaint on basis of which all the proceeding initiated.
Well, kindly done. I think, my lord, management probably has not gone into.
Then to both address.
This was forwarded to the Deputy Secretary, West Bengal Secondary Education, Deputy Secretary Academic. And then page 91, inquiry report regarding allegation against Asik Iqbal. Therefore, this is all prior. I beg to submit the inquiry report in the matter of allegation against Asik Iqbal, so and so, for kind information, taking necessary action. Where is that inquiry report? On 8th November, these are all undated letters.
That is disclosed in the earlier petition, your lordship, because charge sheet issued in 2022. And this is prior to that. All are part of charge sheet. They have annexed, your lordship. It must be with them.
Quality different. Now, but then if that is so, they ought to have said that the copy was served on you, Apia. You record at page 124. He has sent a letter dated 31st October in which he has confirmed the receipt of the letter.
Now let me hear the board. Yes.
Lordship, first, your lordship, kindly come to page 50 regarding that POXO, your lordship, which the learned court said it is not maintainable. Why? Because here, well, at page 50, the learned advocate prayed for bail on the.
No, will not go to POXO.
No. Here the POXO, it was not maintainable because it was filed by a teacher, a female, not the child. But my lord, may I submit to lordship here?
This order.
Yes.
Which is here.
This is not a new complaint.
122 to 125, right?
122 is the order.
Findings. Page 124, first finding is there is no representative from the office of the DI. Second is the person against whom the complaint is made is also absent, and he had made a written representation prior thereto that he doesn't have the copy of the complaint. Third point is the 3 present assistant teachers and 2 ex-assistant teachers absent. What hearing took place on that date?
My lord, may I submit? This hearing is the final hearing. Inquiry held by the.
Nobody was present at the time of hearing.
This is a show cause. My submission is this writ petition is premature. Why? Because this is not a final order passed. This is a show cause. He has been show cause to reply. Why such action should not be taken against him. So he has an opportunity to reply to the show cause. Thereafter, my lord, after considering the show cause, my lord, a final order will be passed. Then, my lord, his cause of action rises. If a final order is passed, then he can come up. Well, this is premature.
Where is the basis? Show me the basis. This show cause has been issued upon a hearing.
After conclusion of the disciplinary proceeding.
Where is the hearing? Where are the parties present at the hearing? What did the authority, this president of the ad hoc committee, who did he hear? He didn't hear anybody because nobody was present. Nobody was there to make any submission. There is only the president of the managing committee who submitted orally and also in writing.
But documents were present before him, your lordship, because the check
Did
and
you
history.
answer the petitioner that I do not have the papers? Was any reply given?
No, he has the papers. That is not the correct submission by him, because this is not
There
a
is
new
no
paper.
reply from you.
Charge sheet contents on papers, your lordship.
My lord, kindly hear me for a moment, my lord.
Not you.
My lord, kindly hear me for a moment.
Just
My lord,
wait.
may I submit one more thing, my lord? If the report which I have filed, my lord, in the other matter, my lord, you
There
will
is-
find the
there
girl
is already
students
a
and the boy
request
students, my lord, they have made series of
upon the
complaints.
district inspector of schools to conduct an inquiry. It was in 2019. What is the fate of that inquiry?
Report was submitted to the board.
Where is that report?
But I don't have that report.
Bring that report.
I'll bring that. But what I have been informed that the earlier petition, that inquiry report has been annexed.
It's item 17.
Bring that.
My lord, kindly hear me for a moment.
Well,
My lord,
both the
I beg your
repetition
lordship,
hot
my lord.
together, your lordship.
My lord, kindly hear me for a moment, my lord. My lord, a minute's time, my lord. I beg your
You are
lordship.
transferred.
My lord, kindly hear me for a moment.
No, you are transferred. What interest do you have in the
My
school?
lord, kindly hear me. Not in the school, my lord, in the proceeding, because I'll tell you, lordship.
In
My
the
lord,
proceeding, go before the board.
no, I have been to. I was.
You go before the board.
I was there. My lord, kindly hear me for a moment, my lord, because all the facts that have been placed before your lordship and pick and choose, my lord, with deepest of respect, my lord. The complaint that was initially lodged, all the complaints that have been shown to your lordship on the behalf of the petitioner are after the date of that complaint. And the POXO case, my lord, there was initially a charge sheet that was subsequently the concerned court directed for further inquiry. A lady DSP conducted inquiry. 15 students have recorded their 164 statement.
that is in the
They have been
report.
abused in the school premises by this country.
Both the girl student and the boy student.
My lord, how I am involved, my lord, kindly call for the CCTV footage of the board. On the date of the hearing, this person was present in the premises. He threatened the other, they couldn't enter. My lord, kindly call, he was there. My lord, I am under instruction, my lord. Those two assistants.
She was not there.
Yes, I was there. I was there. I was there. My submission was there.
She was transferred.
My lord, two of the teachers who were present, those are transferred. The teachers who was present in that school could not appear because of that. The final, my lord, in item 1789, the report of the board.
And this CCTV footage of the board's office?
Yes, my lord, he was present in that day.
All right. Very well. Let the board will take steps. Please come.
No, my lord, one more thing, my lord, may I submit one more thing, my lord? In the date, my lord, kindly keep both the matter together. My lord, let the other writ petition, another writ petition filed by the writ petitioner, my lord, where the report has been submitted, my lord. Let both the matter appear together, your lordship. Then, my lord, everything will be clear before your lordship. Series of allegations before this, against this headmaster.
My lord, both the inquiry reports are filed in that writ petition.
Both the inquiry reports are in the writ petition, your lordship.
What is the date? 125. I cannot read.
No date. No, undated.
No,
No,
125 it is
date
fine.
Last একটা date আছে।
But it is very less.
5/10/2025.
It cannot be 10.
11 হবে না? 5/11/2025.
কিছু বোঝা যাচ্ছে।
হ্যাঁ, একদম একটা সই করেছে। না, যবে আরে কবে হিয়ারিং এ ডেকেছিল সেই ডেটটাই তো হবে। Then 4/11. No, President have the power, my lord. I'll show before your lordship. Yes, my lord. President have the power. I'll show before your lordship. If this question arises, I'll satisfy the lordship on that point.
Ad hoc committee,
Yes,
with
have the
the
power.
Board of Secondary Education. Annexed at pages 122 to 125 of the writ petition is impugned in the instant writ petition. Step. Submission is that the copy of the complaint relying on which the inquiry was being conducted, not inquiry, the disciplinary proceeding was being conducted, was never supplied to the petitioner. Step. The petitioner requested the authority to forward the complaint, but the same was not forwarded. Step. The violation of principle of natural justice has been pleaded. Step. It has been submitted that there is already a direction by the Director of School Education. By the Education Officer, page
Deputy Director.
Deputy Director, page 54. 54, by the Deputy Director of School Education. within bracket AIS, stop, West Bengal, way back on 23rd September 2019, directing the District Inspector of Schools, within bracket SE, North 24 Parganas, to cause a complaint, to cause an inquiry on the complaint filed by the petitioner, and to submit an action taken report. Stop. The inquiry has not been conducted till date. Stop. Next. Prayer has been made to set aside the impugned order. Stop, not stop, as the basis for initiation of the disciplinary proceeding is illegal. Stop. The aforesaid submission made by the petitioner is opposed by the learned advocate representing the respondents. Stop. Learned advocate representing the board submits upon instruction that all documents pertaining to the disciplinary proceeding was duly served upon the petitioner. Stop. The petitioner is aware of all the complaints and the allegations made against him. Stop. He deliberately did not appear for hearing. Stop. The learned advocate representing, it has further been submitted that the writ petition is immature, is premature, and the petitioner ought to file reply to the show cause. Step. Next. Learned advocate representing the state respondents submits that the inquiry report pursuant to the direction of the Deputy Director of School Education is already filed before the court in the earlier writ petition, which is filed by the petitioner pending consideration before this court. Stop. Next. To ascertain the allegations made by the petitioner, a report by way of affidavit is required to be filed by the respondents. The board and the District Inspector of Schools are directed to file separate reports disclosing all facts, documents, facts and documents. Stop. Let the report be prepared
Put in form of affidavit.
and circulated within a period of 4 weeks. Will be all right with you all?
Lordship.
Reply, if any, within a fortnight thereafter. Stop paragraph. As it appears from the impugned order that the representative of the DI, the petitioner and the assistant teachers of the school were absent on the date of the hearing. Accordingly, the order passed on the said date is directed to be kept in abeyance till 31st of March 2026 or until further order, whichever is earlier.
That matter to appear?
Immediately. List the matter immediately on completion of the aforesaid time period. 4 weeks and 2 weeks. Take this back. Take this back. Affidavit of service filed on. If you want to add yourself,
I've tried to interfere.
you make application for addition of party.
I'm grateful.
হ্যাঁ এই অর্ডারটা কেপি নেবে ঠিক আছে কবে হবে না
Give the other number so that it can appear.
1739.
আইটেম নাম্বার বলছিস
Item number 1739.
Combined list. Let this matter appear along with item 1739. নাম্বারটা দেখে নেবেন তো WPA নাম্বারটা
29491 of 2024. 29491 of 2024.
29491 of 2024.
there is a can also.
That's my can for additional party in that.
Yes, then you'll already
And
be
that
added.
expedition.
That
All
has
right.
been added, my lord. Not
All right, the court will see. দেখে নিয়েছেন
And I'm grateful.
1739 দিয়ে দিয়েছে।
Well, the matter will be appearing in the monthly list of March.
No, no,
He mentioned
Immediately there. 4 weeks.
after completion 4 weeks, 2 weeks.
Liberty to mention.
I'm grateful. I'm grateful.
So far 24 is concerned, lad. Yesterday, lad, I have received lad, the soft copy of the report. Lad, I shall use an exception to that, lad. Lad, can I take it up in the next week, lad?
What is your prayer?
Lad, they say initially before the contempt court, they say they have missed my OMR sheet. It's not traceable in their office.
Which examination?
Lad, 12th RLST held in 2011, lad.
11.
And lad, petition was filed immediately after the result was published in 2013.
All right.
13, the writ petition was filed. Ultimately, the writ petition was disposed of, directing reassessment of the OMR sheet and as well as the issue relating to the out of syllabus question. But ultimately, marks was given to all,
Including you?
not except me.
Except you?
They
Why?
they say
It fall within all?
no, they say my OMR sheet is not traceable. Now, I supply a copy of the OMR sheet that was with me, the carbon copy. Now they are saying that they cannot this is
Verify it.
not illegible. They cannot verify it. Now, they have disclosed marks in the contempt proceedings before assessment. What I was awarded with.
Before assessment means? Before assessment, how can marks be given?
The first assessment, which was under challenge.
Yes. How much did you get?
Only 0.25 was short.
All right. And if the marks which have been allotted to
I only it will 6 question was under challenge,
6.
And that apart, out of syllabus question was there. For that, marks has to be allotted to everyone.
And they gave marks to all in how many questions?
They have given marks to all 5, to some 3.25. All this, I have annexed in my repetition.
5 marks given to all?
Yes, in some cases, yes. Kindly take some page 56 of my repetition.
Where fraction of marks makes a lot of difference, the question is allotting 5 marks.
Because number of mistakes was
huge.
More than 5.
Out of syllabus question. Then what is to be done?
They should award these marks and allow me to participate in interview. That was the direction in other matter also. In case of other petitions also.
But the coordinate bench did not allow it.
Other
That
benches?
was, yes. The
Other
bench which
benches-
allowed all others did not allow my learned friend.
Did not allow. No. All right.
This is
And the reason for not allowing?
yes.
The reason was that what my learned friend is saying, we had submitted before the court that all the OMRs are not traceable due to the long delay. Some of them could not be found. We pointed out, it is not that the petitioner came up with the copy. We pointed out in this particular examination, all the candidates were given a copy. So those whose OMRs were not traceable, they gave us their carbon copies. And we assessed them and we gave the marks. My learned friend's OMR was not readable. It could not be scanned. So that was pointed out to the court. It was stated in our affidavit of compliance, and the court did not allow or did not permit that this candidate's OMR should be further reassessed.
All right, tell me one thing. Are you apprehending that the carbon copy of the OMR that is supplied to you by the petitioner is not genuine?
Is not?
Genuine.
No, that I have not said once. But it was not readable. Let my learned friend produce it. He had produced it in court.
It is you who supplied that copy to him. It is not that the petitioner generated the carbon copy.
No, he generated it because we gave the blank copies. He filled in the OMR. He filled in the OMR with the carbon copy. And he took his 3 copies were given, one for the commission, one for sending for the scanning, and one for the candidates. So he has filled in the OMR and he has kept it. Possibly it did not become illegible due to his filling up. It became illegible due to him not keeping it properly because it was a carbon copy. It got rubbed, possibly. Let my learned friend file the exception. Let him spell out exactly where his grievances are, even after our explaining everything. And let him also produce the OMR which he has.
All right. And the allegation of the petitioner that you've given marks to all the candidates except him.
That is his way of putting it. What happened was there were 73 candidates in multiple writ petitions together, 6 writ petitions, I think. And this was actually with regard to the TET answer scripts. That comes in the OMR form. So initially, there was the challenge that the model answers to the TET examination are not correct. Court initially, as a test, directed that, okay, it is divided into 3 parts, the TET paper. So 3 subjects. So you send one for reassessment and certain changes cropped up. Subsequently, the court directed that, okay, all 3 parts, English, Bengali, and child pedagogy, let it be reassessed. It was reassessed and the reports came from the experts. On the basis of that, we were told to check the OMR sheets and then give consequential benefits. Ultimately, 63 candidates succeeded. Simply enhancing the mark.
If somebody answers and you give marks to all, this is not proper.
Yes.
If he attempted the question,
yes,
get the mark. This is not.
No, if the answer script is available, and suppose I am claiming that the answer should be B.
B.
But I can only get the mark if I have answered B. If I have answered C, I will not get it. That is why it became necessary to rescan the OMRs. Since
that you are giving marks only on attempt.
Yes, we are not.
You are not.
No.
All right.
This is the situation.
All right, you file your exception. And where is the original OMR?
If you just kindly take some let first let writ petition page 81 split.
7805? 7805?
Yes, ma'am. But the order passed in this writ petition once minute kindly take some let page on 26 August 2025.
Yes.
Now, in this writ petition, this order was passed. But kindly take some let next page. 6. Concerned authority of the commission is directed to file report in the form of affidavit disclosing whether OMR of the petitioner relating to teacher eligibility test of 2011, which was conducted prior to 12th regional test 2011, was assessed or not. And if the OMR is not assessed, the reasons for not assessing the said OMR in terms of the order dated 29 June 2022 passed in the writ petition being 13. Now, last order passed in the contempt, because all this submission now he is making has made before the other coordinate also met. After that, this order was passed. Now, page 80 of the writ petition. The last order passed in the contempt.
Yes.
This court, second paragraph. This court is of the view that 63 candidates have been declared successful after court's order dated 29th June 2022. The contempt application need not be kept pending any further. any individual cause of action as regards non-qualification of personality test, alleged non-receipt service of notice of personality test, and disclosure of marks may be agitated in the separate independent fresh petition. That's the reason why we have approached. Now, let kindly take some let the a report filed before the contempt court at page 66. I'm just referring the relevant part only. Page 66, paragraph 7, last 3 lines.
Yes.
However, one candidate whose OMR was not traceable, but was later supplied by the said candidate, could not be rehabilitated as the OMR sheet supplied by the candidate was not legible at all. Now, this I have supplied the original. Original mean the carbon copy that was supplied to me. Now, I have with me only the photocopy of that carbon.
You do not have that carbon copy either.
No, because I have supplied to them.
Original handed over to them?
Yes.
Dhaka, receipt Dhaka?
Sir, please.
I will check with
If
the authority.
by court's order, because of court's observation, if I hand over the original,
Show me that you handed over.
blood,
However, one candidate whose OMR was not traceable but was later supplied.
it was between the two learned advocates. Court's observation, learned advocate representing the petitioner in contempt went to the chamber of the learned advocate representing the commission and hand over the original. But if somebody now,
is the council the same council?
I don't want to make that remarks, but whatever I have submitted, I think this is good enough to
Check with it because it was the candidate's copy. So there was,
I don't want to go to that extent.
no, you need not go to that extent.
Now,
Because I can also go to a certain extent also. Let us
Now,
not to squabble. Let us try and solve it.
Now, after this, the report was filed by them. Yes. Now, kindly turn to
And when you took the photocopy of the carbon copy, could you read anything?
I have annexed. In the writ petition, I have annexed it.
Where is it?
79. I think it is readable.
No, I do not know.
Yes, there is confusion in some cases, but most of them are readable. Plus, you can find it from this, at least from the photocopy.
Once you make photocopy of photocopies, you can do whatever you feel like.
I have the original.
That I am not
That
saying.
experience I have.
Yes.
No, it
Not
looks
the
like
one
that.
has
It looks like that.
Yes.
That experience,
Each
don't
dot is
I don't
overwritten.
want to go to that extent.
No, I also
What is admitted position is at page 56.
Chalo, 56.
This is the report that they have filed in the contempt.
56, yes.
This discloses marks of all writ petitioners
Previous and
now. Before assessment and after court's order. After assessment. Now, so far, this petitioner is concerned, kindly take some 81. Serial number 81, second last.
Yes, Muhammad Abdul Sadiq.
Sadiq.
Yes.
Now, kindly see, he has obtained before court's order 48.75.
48.75.
Now, there are these marks, the right hand side column, the marks given to others. 4.75, 4.75, 4, 5, 2, 3.25. Now, kindly turns up to the order first passed in the writ petition, which was under contempt at page 20. What was the direction? In contempt, what we did, whenever this state, whenever somebody has obtained the qualifying marks, we did not challenge any further, because that is all that we require, because it will not be added in the
recruitment process.
Recruitment process. Therefore, we didn't challenge whether they have given full marks or more marks I need. We didn't challenge that. But the direction at page 20 is, kindly take some at page 21. This is important. Page 21 of the writ petition.
Yes.
second paragraph, rather third paragraph. The commission may take suitable steps in terms of the opinion of the experts upon intimation to the learned advocate on record of the petitioner. These also they have not done. If the answer keys of the question in the OMR sheet in child development and pedagogy is found incorrect, or more than one answer is found correct, the commission shall award marks to the candidates for the said question. All the consequential benefits shall also follow to the candidates who obtain such additional marks. Then, in addition to the allegations made in paragraph 10, the writ petition with respect to child development and pedagogy subject, the expert may also consider as to whether any question outside the syllabus were mentioned as alleged in paragraph 14 of the writ petition. Now, my lord, there was no scope for my lord, putting question from poem. It was from the prose.
Whatever.
Now, my lord, they are supposed to my lord, assess and give marks. Now, my lord, they have given marks to others. Initially, my lord, they file a report with the contempt saying that only a limited number of candidates were qualified. We raise objection that you have not done this assessment in terms of this order. Then they have come up with a fresh report. Another compliance report. And they have qualified the rest, except this man. Well, this is the present scenario. Now, I am short of only 2.25. All of the candidates as at least
0.25.
0.25. 0.25.
All right.
Only 0.25.
And each question is of how many marks?
Is of 1 marks. Is of 1 marks.
And how can 0.25 be the difference?
They have given that they have done when they, in the affidavit in the previous petition, they say that the question is partially correct. The answer is partially correct. They have given 24.2.
It's OMR. How can it be?
That was
correct?
That was not accepted by the court, and court has specifically directed if there is 2 answer is correct, give full marks. Therefore, the assessment is not correct. Now, they are if they misplace my answer script when the petition is pending, particularly, that's my mistake. For that, they have to take the responsibility. Why shall I?
All right, you filed exception. Let us see what happens. Affidavit by the Regional School Service Commission. Is it the regional?
No, central.
Now, Central School Service Commission. In court today is taken on record. Stop. The petitioner seeks time to file exception to the same. Stop. Let exception be prepared and circulated by 16th of January 2026. Release the matter for further consideration on 4th February 2026. Stop. Learned advocate for the petitioner submits that the original.
The carbon copy of the original.
That the carbon copy of the original OMR sheet was handed over to the learned advocate representing the commissioner. Stop. The learned advocate for commission shall verify the same and produce the carbon copy before the court if the same is available. Let us see what happens.
The opposition may be
carbon copy is with them.
Yes, yes. This is what I have recorded.
Lordship, 25. 25 is the.
Is it different?
It's very similar.
Separate
Yes,
report.
Lordship, here it's a question where the candidate has qualified. Her only objection is that she did not receive any intimation regarding the personality test and interview. That's the only short point. It was supposed to be intimated to the candidate as well as to the advocate. Lordship, I shall go through that order, but she did not receive anything.
When did the interview take place?
Lordship, the 2030.
date লেখা আছে।
Lordship, during the
বললাম।
pendency of the contempt application. All right, Lordship, we have repeatedly come, the only plea of the School Service Commission is we have sent it to the right address. She ought to have given, but there is nothing said about whether the advocate has been intimated, as was the order of the Honorable Court. Lordship, that's the short point. She has qualified.
Any
there is
report
no
did you
denial
file over
after
They
here?
have filed our opposition, but they have not given any reply to the opposition.
Where is your, yes, opposition is here.
Lordship.
November 2020.
3. এই তো নাকি, হ্যাঁ।
Did you get a copy?
কি করে হবে ভুল এই ডেটটা
So,
ভুল লিখেছেন
November 23.
মিস্টেকেন
আরে স্ট্যাম্প দেখে বলছে, হাইকোর্টের স্ট্যাম্প ভুল হবে।
Yes.
23 এফিডেভিট
আরে সব
It is in November 23. Has it not been served from 23? 25 was over.
নো
Then where is your exception? They must have taken some point over here.
Lordship, may I read out what they have said?
Yes, please.
With regard, Lordship kindly comes to page 5, paragraph 7. With regard to the statements made in paragraph 8 of the writ petition, I do not admit any statement or averment contrary or inconsistent with records. With regard to the order dated 29/6/2022 passed in WPA 450 of 2013, Lordship, I shall take your Lordship to that order. I say that all steps taken by the Commission were intimated and were within the knowledge of the learned advocate on record of the petitioner. I say that as the steps taken by the Commission were taken in course of hearing of the contempt application being so and so, the Commission intimated all steps taken to the Honorable Court by filing multiple compliance reports, copies of which were served upon the learned advocate on record of the petitioner. All orders passed by the Honorable Court were also made in the presence of the learned advocate on record of the petitioner. Hence, separate intimation with regard to the steps taken was not necessary, and the learned advocate on record of the petitioner was fully aware of the fact that personality test was to be held and which were the qualified candidates. Admittedly, I have admittedly, I know that there is going to be a personality test along with an interview. But how am I supposed to know the date? I am aware that a test will be taken, but when is the date being fixed, Lordship? That is not possible for me or my advocate on record to know. By intimation to the learned advocate on record of the petitioner, the Honorable Court could not have meant that the learned advocate on record should be personally intimated that on which date intimation letters are being posted to which address.
All right, just wait. Can anything be done over here?
My lord,
Please be.
firstly, the coordinate bench heard this issue.
Whatever.
It is not allowed.
Because the candidate qualified in the examination, submission is that he or she was not aware of the date of the personality test.
No, but this is incorrect. Kindly look at page 3. Kindly look at page 3.
From page 4 of your affidavit, I also see that there was a service, attempt of service. It could not be served because the person concerned was not there, and he also did not take steps to collect the intimation
Petitioner
letter.
number 1. Let us first see the petitioner number 1.
There are
Page
two
3,
petitioners.
paragraph D, subparagraph D. At
Two
the bottom.
petitioners.
There are 2 petitioners. They have clubbed themselves, though their cases are different.
All right.
With regard to the petitioner number 1,
yes,
I say that from the track report, it appears that the intimation to appear in the personality test was served on the petitioner number 1 on 13/4/2023. In the said track report, it is annexed to their writ petition. They know about it. In the said track report, the current statement is shown as item delivery confirmed.
Not found.
The intimation was sent to the address of the petitioner number 1, which was mentioned in her online application form. So it went to the correct address. It reached the petitioner. The petitioner did not show any interest to attend the personality test. The petitioner number 1 never intimated the commission with regard to any change of address. And even in the contempt application, which was filed as late as 2022. The petitioner number 1 has used the
All
same
right.
address in the court
Petitioner
title.
number 1, I understand. Then the next is petitioner number 2. Just wait. Petitioner number 2, the service could not be affected.
Yes, service could not be affected because the addressee could not be located at the address. The address was correct. It was not that it went to the wrong address. With regard to the petitioner number 2, I say that the track report, it appears that the intimation for participating in the personality test could not be delivered as the addressee could not be located at the address where the intimation letter was to be delivered. The petitioner number 2 also did not make any immediate attempt to collect the intimation letter
Yes,
from
I've
the
seen
post
that.
office
Right.
and collect the same at a later date.
Your Lordship,
So
At
both of
least-
them have shown a very casual attitude. That is what fell from the court.
Just wait. At least number 1, for the petitioner number 1, there is something to show that it was served. For petitioner
Lordship, it is
number
not
2,
there. I shall be showing
it is
the
not
Lordship.
so.
Lordship,
Can anything be done in respect of the petitioner number 2?
No. Lordship kindly comes to, for a moment.
Just 1 minute.
My lord, I will have to take instruction.
Please take instruction.
I will have to take instruction, and in case we are to accept it, then we will have to arrange for the personality test of the, which
Only
means again
personality.
I have to constitute a board, call 3 examiners who will take the personality test. Let me take instruction.
Lordship kindly comes to page 83 of the writ petition. That's the envelope which they say that I shall show you, Lordship. This is the envelope, and kindly comes to page 83. NF means not found.
1 minute. Salaha Mondal is petitioner number 1.
Yes.
Right.
Kindly comes to page 83.
Where is your exception? Why did you not file an exception to this?
Lordship,
It was served more
Lordship,
than
I
3
shall-
years back.
It was mistake on my part. I shall show you, Lordship, that they are saying it has been delivered.
Yes,
Kindly
Salah.
comes to the challan, page 95. Item delivered confirmed. Where to? Not the addressee. Not to the addressee. Your
93,
95. page
95. Yes.
Item delivered confirmed. To whom?
Report speaks of to the addressee. Final report. This is not a final report.
This is a secret.
It says not confirmed.
83.
Kindly see the top box.
Top box দেখানো হচ্ছে দাদা।
Delivery location.
Boral SO.
Boral SO.
That's not the
Delivery confirmed on so and
এটা
so
নিচে
date.
দেখেন না।
And,
Item delivery confirmed. This is it.
and page 83 shows not found. What does my learned friend have to say on that account? Page
Okay.
83,
On the same day.
on the
Kothai,
same
kothai,
date,
kothai?
not page 83.
83.
13 was the same date. 13/4/2023.
করতে পারছি না, তোমারটা দেখি।
It is NF 13/4/20.
কাম এটা।
Act number, petitioner number 1. I'll file an exception, Your Lordship.
Let
kindly-
the exception come.
Page 82, petitioner number 1, page 82 and 83. Where is the name of the petitioner mentioned?
These they have
This is your writ petition. Whose envelope is this?
এই পোরশনটা লেখা থাকে কিন্তু এটা
It's probably illegible. I'm not denying.
so you can match it from the number.
Yes.
The number that they have given in the page 82
82,
And
5,
with
576,
with
last
the track report,
digits.
with the track report.
Yes, 576. 95, 576, yes.
Yes. So this is the
And-
envelope of
Petitioner number 1.
petition number 1.
And it's clearly says not found.
Page 83 is the back page of the envelope.
Yes.
Lordship, a person who's been pursuing this so vigilantly, will he or she be so careless as to not attend an interview?
Yes.
এবার এই প্যারাগ্রাফটা দেখিয়ে দিন পেজ 11
Kindly comes to page 11 for a moment. 11 of the writ
Backside
petition.
না এটা তোমার
paragraph 11 of the
petition number
Kindly
12.
let me read it out. Petitioner states that it's also pertinent to mention here learned advocate, also called the learned advocate of the commission regarding the fate of the petitioner prior to 18th April 2020, since other candidates had received their letters, but the petitioner did not. In fact, on 18th April 2023, immediately after gathering information from other petitioners that they were called for an interview on that day, learned advocate of your petitioner called the learned advocate representing the commission at about 3:30 p.m. to ascertain whether any notice has been issued in favor, inviting to participate in the interview. Kindly comes to what they have said regarding paragraph 11 in the affidavit in opposition.
No, but then pages 82 and 83, where from did you get it?
Which of the this
Subsequently, I have received it from the post office. Yes.
Subsequently?
But after we have ascertained that interview is held, now that we wrote a letter on 19th, but on 18th, the date of interview, 18th at 3:30, that learned advocate representing the petitioner called the Honorable Commission to ascertain whether it was served on me also. Now that nothing was disclosed. Immediately, on 19th, wrote a letter to the commission that I have heard this. Kindly ascertain. I have also informed that my name was also there. No, not replied. Now that went to the post office. Subsequently, on 28th, this envelope was received from the post office.
So you say all these things in your exception?
Yes.
Because the postal track report says it was served upon the sub post office.
Yes.
SO.
Yes.
So whether it actually reached the candidate or not is not very clear. And moreover, with the initial NF, in the meantime, you take instructions.
Yes, yes, I'll also check, I'll verify.
On the prayer of the learned advocate representing the petitioners.
I'll serve it within
Time
3
to
days.
file the affidavit in reply is extended till 16th. আগেরটা যবে আসতে বললাম এটাকে বলে 3rd of February.
On the same date, you will
4th of February. Same day.
Deeply obliged.
না with না আলাদা হবে. Absolutely separate.
My lord, I'm for the petition in this matter.
Yes.
Last occasion, my lord, there was a direction upon me to serve upon the school authority. I have served upon the school authority. Possibly, my lord, they have chosen not to appear. My lord, may I place the case, my lord? My lord, this is regarding the cooking and
Engagement of self-help
self-help
group for running
what
the midday
happened?
meal scheme in a school.
Yes, yes. Now, what happened exactly? The petitioner.
This is not an education matter.
Yes, yes. My lord, your lordship has previously passed order on the similar.
That
No,
I have passed order.
my lord, it is because it is governed under the school education department memo. The school authority engaged me. And my lord, kindly see, my lord, kindly come to page number 27 for once. Kindly come to page number 27 for once. And previous several orders have been passed, my lord. And my lord, I have already handed over similar and identical issue lordship passed order in this
No,
matter.
I am not satisfied.
May I just show, my lord? May I just show? There is a notification also. It is under the school education department.
All right, assuming it is under the school education department, I am not satisfied with your prayer and the grounds made to get
But
that
I
prayer.
am covered by the similar and identical
Said
issue.
all covered.
May I show? May I place my
Yes,
case, my lord?
please.
Yes. My lord, kindly come to page 27 for once.
You want to continue with the
Cooking,
supply of midday meal.
cooking and serving, yes. Now, my lord, I tell you, lordship, since 2008, petitioner was engaged. 2009, my lord, there was a direction of the concerned district magistrate that the existing self-help groups will continue. Now, my lord, we have been continuing, no problem. Suddenly, my lord, 2015, the concerned BDO issued a handwritten notification that rotation system will be introduced. Now, the rotation system was introduced, then the situation became worse. In 2023, my lord, since 8 to 2023, we have been cooking. 2023, a group of self-help groups, unknown people, they came, they put padlock and they threw us out. Now, my lord,
a report to be.
my lord, may I just place, but I need to place certain documents. Kindly allow me to place these documents. Now, the concerned notification was
Because
withdrawn.
if two self-help groups fight amongst themselves, what is to be done?
It has been
You
settled.
can't-
My lord, it has been
My lord,
settled. with the three coordinate
in earlier
order.
occasion, my lord, I have shown your lordship, my lord,
Ah.
relevant rules, my lord, which shows, my lord, that this is the absolutely, my lord, prerogative of the, my lord, concerned school authority, my lord. I'm showing your lordship, my lord, again.
It is against the judicial orders. Then.
No, no.
It's not a rule. It's a hand. This is not a
The
rule.
I'm showing your lordship,
school is unable to fix up any self-help group
my lord.
because There are two groups which are fighting. In that case, what is to be done?
Well, it has this situation has come up before also. My lord,
Yes.
kindly see, I'm showing.
Have
That is why I'm
placed it
showing.
before
But
the
may I just get 2 minutes of your lordship's time? My lord, kindly see that notification was withdrawn. Then subsequently, my lord, we lodged complaint. Now, my lord, kindly see similar situation came up at page number 39.
Yes.
This was also your lordship, pursuant to lordship's order. Kindly see similar situation, same district, same video. Kindly see the order, page 39. My lord, this is I'm placing, my lord. Please refer to the direction of the Honorable Calcutta High Court in WPA number such and such, directing the undersigned to inquire as to whether the petitioners, that is Shingovahini, Shonirbhar, Shomiti, self-help group, and other were performing the cooking under
Order of the coordinate bench is not binding upon your lordship.
Your lordship's order is there.
To cause an
Will
inquiry.
scheme in the Icha Girls Primary School. The undersigned was also directed to give an opportunity of hearing to the petitioners and all the necessary such and such. Accordingly, an order was passed by the Sub Inspector of Schools, Chalda Circle 1, to cause an inquiry into the case details and submit his report. A report was also sought from the teacher in charge of the Icha Girls Primary School. The Sub Inspector of Schools, Chalda Circle 1, submitted his inquiry report with a memo number such and such, explaining his findings. The teacher in charge of Icha Girls Primary School to submitted his report with a memo number such and such dated 5th of July 22. Upon inquiry, the undersigned found that since inception, that is in the year 2004, Shingovahini Shonirbhar Shomiti had been cooking and serving midday meal at Ichak Girls Primary School successfully without any objection and allegation from any corner till unauthorized forced discontinuation by 4 other self-help groups, namely New Kandeshwari Mohila Shomiti, Matara Mohila Shomiti, Jagottarini Mohila Shomiti, and Mamonosha Mohila Shomiti on 5th January 2018. Further, it transpires from the report of the SI of school, Jhalda Circle 1, as well as teacher in charge of Ichar Girls Primary School, that the midday meal provisioning in the said school was restarted in the latter part of 2018 in its current prevailing form, wherein the above 4 rival self-help groups started operating the functions of midday meal on a monthly rotational basis, along with the petitioners due to an informal local arrangement with a haste to restart the midday meal program in the benefit of the school children. Upon examining all the reports and thorough inquiry into the case by the undersigned, it is decided that the claim of Shingovahini Shonirbhar Shomiti as to function as the sole SHG for cooking and serving midday meal at Icha Girls Primary School continues to hold legitimacy, and the standing of the other self-help group is not legally tenable, as their act of putting padlock to the kitchen on 5th July 2022 for no valid reason was unauthorized and unwarranted. In light of the above, the teacher in charge of the Icha Girls Primary School is hereby directed to restore the engagement of Shingovahini Shonirbhar Shomiti from 1st August 2022 as sole self-help group to cook and serve midday meal to the students. Now, your lordship,
So the
kindly
teacher
take-
in charge was directed.
May I not be interrupted? I'm placing my case. My lord, kindly take your lordship's order. This is your lordship's order. This is the identical situation. Your lordship passed this order. Similar issue, same district, same issue, my lord. This is your lordship's order. Previously, Justice, my lord, Justice
Who
Chakraborty.
is supplying the meal now?
We are ousted. Some groups, they have come at their own discretion and volition. They are coming. They are putting padlock, cooking, distributing food. They are going. It is their own self arrangement.
And the school is not taking any steps?
School cannot. It is under the BDOs. That's what I submitted. Since BDO issued one order that rotation will be introduced, though it was withdrawn subsequently. That has been recorded in the my lord Justice Chakraborty's order that I had handed over. The lordship kindly takes
Right
this
now,
yes.
who is supplying? Somebody else?
Court, several numbers of self-help groups are coming. They are doing at their own volition.
You are also doing?
No, I am not there. I have been ousted in 2023. I
Yes.
cannot. Now, my lord, kindly see these 2 orders, your lordship, and this is the third order. This is the third order. Everywhere there is a constant stand of this honorable court.
Please come.
Well, kindly see your lordship's order for once and Justice Chakraborty's order, my lord.
The matter relates to cooking and supplying midday meal in school. Stop. The petitioner claims to be in charge of cooking and supplying the midday meal to the children of the school at in the past, but alleges that the self-help group of the petitioner has since been ousted. Step. It has been submitted that there are several self-help groups who are performing the aforesaid duty at present. Stop. The petitioner is not getting a chance. Stop.
As the pre-existing self-help group.
The learned advocate representing the state respondents relies upon the guidelines relating to cooking and supplying of midday meal program of the state. Now, relating to the midday meal program, cooking and supply of the state.
Yes, I was engaged by the school only.
It appears therefrom that the headmaster / headmistress / teacher in charge is the pivotal person in running the midday meal scheme in the school and to ensure uninterrupted running of the program. Stop. The village education committee and the managing committee of the school are to monitor the midday meal program. The committee is to engage the self-help groups following the norms prescribed. Stop. In the instant case, it appears that there is constant infighting between the self-help groups to perform the service of providing midday meal to the children. Stop. Despite notice, the school is unrepresented. Stop. In view of the above, the DI is not a party. The village education committee is not a party.
Since I was engaged by DM's order, my lord, because DM had
in the
I was engaged by school.
In view of the above, the district magistrate is directed to consider the grievance of the petitioner after giving reasonable opportunity of hearing to the headmaster of the school, headmaster / head teacher of the school, and the other necessary parties, and particularly the self-help groups who are performing the duties of the midday meal scheme in the said school, and find out a solution to the problem that has cropped up. Stop. A decision shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. The reasoned order not reasoned order. The decision of the district magistrate shall be communicated to all the parties. Stop. At the time of taking a decision in the matter, the guidelines framed by the state in respect to the midday meal program of the state shall be taken note of. Stop. The writ petition stands disposed.
Well, I may be allowed to submit documents in that.
All parties will be permitted to rely upon documents in support of their respective stand.
I'm grateful to Your Lordship.
Deeply obliged.
Can I take back this order.
Take this back.
These orders, yes.
It is
Yes, yes.
Where is your affidavit of service?
No, my lord, I just delivered, my lord. I have checked personally, delivered.
The notice, beginning to the notice showing service upon the headmaster. Who is there? Headmaster?
Headmaster, yes, yes.
আর in the cost title you mentioned head teacher, তাহলে ওটা headmaster করে দেবেন, যেটা head teacher বলেছে না? Headmaster slash teacher in charge of the subject school, including the postal receipt and the track report.
আমার instruction
Filed in court is taken on record.
না জজ সাহেবের কাছে এটা অর্ডার গুলো এটা এই যে কোর্টে রাখা আছে। আচ্ছা কোর্টে order. I've served upon the police authority also. ডেলিভার্ড হয়েছে দেখেছো তো সবকটা ডেলিভার্ড আছে তো
Very well.
Grateful, your lordship. Deeply obliged. Much obliged, your lordship.
T7 will offer the petition.
27 I appear for state respond.
At the last occasion, Lordship was pleased to direct my learned friend to file a report. But
Here is
report
a-
has been filed.
But I have served my learned
The
senior.
report has been served, my lord. My lord, I have perused the report, my lord. I think that it is not necessary to file any exception. My lord, from the said report, my lord, I make my submission, my lord. My lord, kindly see my learned friend submit that the government memo.
Rejection order is at page?
Yes, my lord. The rejection order, my lord, page 30. Page
All
30.
right.
Only, my lord, the rejection, as per income certificate fund is herewith 50,000 per annum. The applicant is not eligible for family pension. He can earn his livelihood in light of, my lord, memo number
Such and
378.
such. Hmm.
My lord, kindly see my income certificate. This is not my own income. This is my family income.
Hmm.
My lord,
Yes.
page 21. Page 21, my lord.
Page 21.
Yes, my lord. The annual income of his family,
Hmm.
50,000.
Hmm.
And my lord, kindly see, I am the physical handicap person. My lord, page 20, the physical handicap, my lord, the 70% physically handicapped. My lord, physically
Alright.
handicapped. Now, my lord,
Yes.
this memo, my lord, does not speak about the slab of, my lord, the income. Kindly see, my lord, my learned friend has, my lord, annexed in the said memo. There is no whisper to, my lord, the income slab of 3,500. Only, my lord, condition, page 6, my lord, kindly see.
তুমি দিয়েছিলে একদিন।
No, no.
Page 6.
Yes, my lord, page 6. But after careful consideration of the matter, the governor has been pleased to adopt the following procedure for redressal of the such difficulty. In line with the followed, the finance department so. The desirability of the mention, the memo number such and such, when the mention receives the child which has makes him and her unable to earn his her living, the fact should be brought to the notice, the pension sanctioning authority duly supported by the medical certificate issued by the medical board. But I have the medical certificate. The pension sanctioning authority shall on the receipt of the said form get it pasted in the service book and the employee acknowledge the same. In case where the PPO has already been issued without mentioning the name of the children eligible for family pension, the pensioner, if he is so desire, can furnish the list of eligible children of the PSA. Inter alia, indicating also the child of handicap support in the medical certificate. My lord, here the petitioners, my lord, the father of the petitioner was, my lord, died 2007. Well, the PPO was issued. My lord, there is one petitioner's name was not, my lord, recorded in the pension payment order. So, my lord, the subsequently, my lord, 2020-21, my lord, mother was died. Mother was the pensioner. Now the petitioner has, my lord, claiming for as a physical handicap. Then, my lord, the acknowledge of the sub paragraph 2 and 3 above memo, the pay skype of the family member by the legal guardian as the case mentally handicapped children. Well, this is not, my lord, necessary. Then, my lord, kindly see the C. The family pension payable to the handicapped child shall be stopped if he is started earning his her living. In such cases, he shall be duty to legal guardian of incumbent concern to furnish the certificate to trade. So, my lord, only for the if I am, my lord, after receiving the family pension, if I am, my lord, getting the, my lord, started for, my lord, income, then, my lord, family pension. So there is no slab in respect of this slab is, my lord, only restricted to the, my lord, only for unmarried and, my lord, married daughters. Page 90, 96. My lord, kindly see this slab only, my lord, restricted, it was restricted, my lord, family pension for my lord, divorced and unmarried daughter. Subsequently, it was enhanced from 3,500 to 9,000 by virtue of memo issued by the state government. Last occasion I have handed over before lordships, although my lord I am, and this memo has been, my lord, issued in terms of this honorable court's order, my lord. Because
Tell
of
me, who else is there in your family?
my lord,
Who else is there in your family?
my lord, kindly see.
Your mother has died, your father has died.
Other, my lord, daughters are there.
Daughters of the teacher.
No, daughters of my daughters.
Oh, your daughters
Yes, my
are
lord.
there.
I am the, kindly see my legal year certificate. Legal year certificate. My lord, page 26. My lord, the 6 daughters, and I am the only, my lord, brother. My lord, I am the only son of the, my lord, my father, parents.
26.
Page 26.
That means they are your sisters, not your daughter.
No, my lord.
They are your sisters.
Yes, my lord.
Are they married or unmarried?
My lord, there are one, my lord, mother, kindly see the mother died.
Mother died.
And then, my lord, Archana Khan, my lord, the 56 years alive. Apunna Manna.
Are they married?
Yes, yes.
All are married?
All are married.
They don't stay with you?
No. But they are, my lord, taking, looking, they are, my lord, take care of.
No, they are taking care of you is something else. But then from serial numbers 2 to 6, they
Yes,
are
ma'am.
your sisters.
All are married.
Married.
Yes, yes, all are married, and they are also, my lord, husband also, their husband also alive. So, my lord, they are not, my lord, widow. And
right.
Therefore, my lord, the petitioner is, my lord, claiming for the physical handicap as a person who has, my lord, claiming for.
The certificate that you relied upon,
my lord,
mentions about the family income. Where from does the family come?
Because of,
You
my
are
lord,
alone in the family.
There are other land, and my lord, that's why, my lord, that's income has been, my lord,
Other land means you have landed property.
my father was.
Yes.
Yes.
So your father had landed property which you inherited.
Yes.
Which you inherited. So this is the income from
Only.
landed property.
Yes. And that is also, my lord, the share of my
joint. It's a joint property.
Yes. And, my lord, these slabs, my lord, these slabs has been enhanced by virtue of memo of 2023, and this is in terms of this honorable court's order.
2021, I have the memo.
Have you annexed the memo?
No, this 2021 enhancement memo I have, my lord. No, 23 টা 2021 কে rely করে করেছে 23 তে 2021 এর মেমোটা
23 has been, my lord, issued by virtue of this honorable court order because of 6th pay commission has been, my lord, granted
Here is the
enhance of
original memo.
9,000.
এটু জজ সাহেব
So, therefore, my lord, my
এই মেমোটা
submission to
unmarried daughter.
Yes, my lord. Only twofold my submission. Firstly, my lord, 378 memo. There is no whisper for, my lord, slab of, my lord, income in respect of physically handicapped. And if that be so, they have, my lord, adopted in respect of memo 96. Then, my lord, that is also been, my lord, enhanced. This is, my lord, the.
এটা দিয়েছি জজ সাহেব এই this is the memo. But this is the memo that my learned senior friend is relying on for enhancement.
This memo has been issued.
So that is all right. But then see, page 21 of the writ petition is issued by the BDO.
My lord.
He mentions that the annual income of his family is 50,000 from all sources as confirmed and ascertained. Right?
He is a single person in the family.
He is a single person. Where from does this income come? What does he do?
My lord, that is not, my lord, part of this certificate. It has to be, my lord, the assertion might have been done by the BDO.
Yes. What are the income sources
Yes.
which the BDO took into consideration? Because if the submission of the petitioner is taken to be correct, there are 4 or 5 other co-sharers of a property from where maybe this income is generated.
But it is generating in terms of in respect to the petitioner only.
Whether it is in respect of
Yes,
the petitioner
that has
only.
that.
Because it says annual income of his family. He is an unmarried. Are you
Yes,
married?
Unmarried. Unmarried
Unmarried.
physical.
Unmarried.
Unmarried physically handicapped candidate.
And with regard to the memorandums that my learned senior friend was relying, as well as in the writ petition mentioned, but unfortunately, I say this, my lord, the question of physically handicapped son is not there, save and except the memorandum that has been annexed to my report. There, all the specifications that has been made is with regard to the mother, father, unmarried, widowed, divorced daughter. So the question of having the slab enhanced in my humble submission could not have arisen with regard to from 35,000 to 9,000.
Assuming your submission is right, you reject it on the light of GO 378.
Yes.
And this is 378. If you say is in respect of the daughters, then where will the sons go? Then you find out
Yes, that is the unfortunate part I am submitting. It is silent, absolutely. So as an officer of the court, I am submitting this, my lord. I am
Alright.
handicapped with this GO.
In that case, you find out a GO which is meant for the sons.
Sons GO is probably annexed, only GO that is there. So subject to correction of my with my report. Subject, yes. Subject to correction of my learned senior friend.
There is no other geo in respect.
In respect of
So slab in respect of income.
What is to be done?
That is the most unfortunate part. I may empathize with the petitioner, but unfortunately, I don't find a GO. I tried my best to find out a GO with regard to this.
378 family pension for life to children suffering. It mentions about children. It takes care of the sons also.
Yes, my report, only this report is there.
Then why do you say it is only for the...
No, I'm not saying this report. I'm saying the report that my learned senior friend is harping on with regard to the enhancement.
Already, suppose the enhancement is not there, 378 is there.
Yes, and hence, if this report is taken to be sacrosanct, my lord, then in my humble submission, my lord, the petitioner's income is 50,000.
No. Annual income of the family.
Yes, the family he is single person.
Then?
So the annual family means only one, in my humble understanding of this.
Very well. You may make a submission on affidavit that it is only the petitioner who is receiving this 50,000.
Yes, that I have to take instructions from the BDO's office also. And with regard, and with regard to the physically handicapped certificate, I'm not going into the merits, but the dates are very important, my lord. The dates are, my lord, the father died in the year 2007. Thereafter, the mother got the family pension. When the PPO never suggested that their son existed with regard to a physically handicapped person, she died in the year 2021, in the month of April. This handicap certificate is of month of August 2021. Just for a reference, I need to check with the office also. Before that, there was no certificate, which I take to be.
If my learned friend is disputing my certificate.
No, I'm not disputing. I'm not disputing.
Your report, page 5.
Yes, ma'am.
Last paragraph, please come. At present, there is no provision to incorporate the name of the minor children or handicapped children in the PPO.
Yes.
Only the name of the spouse is incorporated. So,
but in the case thereafter, but in the case of handicapped children, it is difficult to claim the pension for the life after careful. Since this was the difficulty, then the honorable governor passes this memorandum. After careful consideration of the matter, the governor has been pleased to adopt the following procedures.
Yes.
The procedures thereafter was laid down.
Right.
The procedure is that, my lord, when the person is getting a PPO, then he has to incorporate the person who is due to be getting the subsequent family pension out of the quota of physically handicapped. So that was not done since.
check his physical status?
Yes.
Whether he is physically handicapped, because he must have annexed the certificate.
Yes, it is there. It is there. From the certificate, I'm seeing the date.
It's issued by the
Medical
district hospital.
Yes.
Please come.
So, my lord, let me file a comprehensive affidavit in with regard to this.
By the director of pension, not by, but on behalf of the director of pension, provident fund and group insurance, West Bengal, in court today is taken on record. Stop. The petitioner seeks pension on account of him being the physically handicapped, not handicapped, challenged, unmarried likhta hai na, son of the deceased school teacher. Stop. Paragraph. The disability certificate issued in favor of the petitioner on 4th August 2021 is annexed to the writ petition. Stop. The certificate of the block development officer certifying the annual income of the family of the petitioner is also annexed to the writ petition. Stop. The annual certificate, the annual income certificate mentions about the income of the family. Stop. The petitioner claims to be an unmarried, claims to be a bachelor. Stop. The other heirs and legal representatives of the deceased teacher are 4 married daughters, who the petitioner claims to be staying separately
I'm sorry,
from
my
the
lord.
petitioner.
I'm sorry, my lord. There is a two son of the deceased. That's why family income has been sent. Bonomali and Haradhan. Haradhan is the one of the.
And 3 sons, 3 daughters.
Yes.
4 bollam to sheta 3 married daughters. Yes. Who the petitioner claims to be staying in their respective matrimonial homes. What does Bonomali do? Does he earn something?
No. But only the farmer is unemployed. The affidavit filed by the Bonomali. Unemployed. Malad, kindly see.
The disability is mentioned when
Unemployed.
You also take care of this memo which you have annexed, which specifically mentions that the disability in the child which makes him/her unable to earn, that is his independent income, not the family income.
When I say this, my lord, on instruction I submit, my lord, he is a single person in the family. That is the reason that the income certificate is.
No, the brother is also there now. He
Brother
says.
is not dependent on him. That is that is my instructions.
So that means brother earns separately.
Yes. Although he is said to be an unemployed, my lord, affirming this writ petition,
All right,
but he
doesn't
has his family to maintain. Separate family.
The full stop dilam to okhane. The deceased teacher is also survived by another son.
2 sons. Aro duto sons.
Another son.
Another son, who the petitioner claims to be a married one and has his own family to maintain. Stop. Paragraph. According to the petitioner, the sum of rupees 50,000 as mentioned as annual income of the family comes from the agricultural land left by his deceased father. Stop. The landed property is a joint one and the petitioner is not the only beneficiary of the said income. Stop. Paragraph. The government order relying on which the petitioner's claim for family pension stood rejected clearly lays down that the disability of the child which makes him/her unable to earn his/her living would be entitled to receive family pension. Stop. The um, the family income certificate mentions about the income of the family and not the independent income of the petitioner. Stop. Paragraph. The state respondents and particularly the block development officer Kotulpur Bakura is directed to cause further inquiry to ascertain the independent income of the petitioner. The source of the income of the petitioner shall be clearly disclosed. Stop. Let the report of the block development officer be placed before this court on the adjourned date. Relist. 24th of February 2026. This is to be taken on record. Yes, please.
What I gather that the block development officer has to file a report in the form of an affidavit then.
Yes, form of an affidavit. You take all these back. A copy of the report of the BDO shall be served in advance to the learned advocate representing the petitioner.
Grateful.
Not affidavit of service.
Yes, service is taken on record.
But I appear for this. On the other day, my lord, I have handed up the PPO. Your lordship has list.
The PPO kindly direct the officer to pay the pension and also why direction is required? If the PPO is there, then it will be automatically paid.
It's automatic.
But pension has not been started. All right.
You go to the treasury, you will get it automatically.
Acha. It appears from the submission made on behalf of both the parties that the pension payment order has been issued in favor of the petitioner. Stop. The amount mentioned in the PPO shall be forthwith disbursed in favor of the petitioner if not disbursed earlier. Writ petition stands disposed. Kindly lordship fix the time, lordship. Forthwith. Immediate.
My lord, my junior was here. I have sent up.
All right.
Now these.
'29, my lord, I have filed an application for addition of parties. Can file
the writ petition, my lord, there are several applications which has been filed, my lord. They are claiming themselves to be similarly circumstanced with the writ petition. The writ petition, my lord, I have challenged. First, kindly sees the last order. I had sought for.
The petitioner's names are listed in the list of the tainted candidates. They cannot participate in the recruitment process. Incorporation of their names.
Yes,
Cannot
and
be
my lord,
treated as
prayer was
tainted.
made for production of.
There are 10 matters of the monthly list. After that, if this matter is to
10 matters.
Prayer has been made to direct the commission to produce a list of candidates in the
same
group
challenge.
who have permitted
Passover indicating that
to
after
appear for counseling. Prayer is to produce a list of the candidates in the group C category who were permitted to appear for counseling and appointed after the expiry of the panel.
Yes, but I had
Right.
on the last.
Since a Passover has been sought for, I'll take up the other matters and then come back to you.
Take it up tomorrow then, my lord.
Tomorrow? Not today. Not today.
Affidavit will keep only part.
আরেকটা পাঁচ ওভার আছে কোনটা সাপ্লাই
রাহুলকে করা আছে হ্যাঁ রাহুলকে দিয়েছি হোয়াটসঅ্যাপে করা হোয়াটসঅ্যাপ করেছি আমি তোকে হোয়াটসঅ্যাপ করে দিচ্ছি
এটা কোনটা
Addition of party.
ওটা ফেরত দিয়ে দিন ওটা ফেরত দিয়ে দিন কিছু রেকর্ড করছি না আমরা
My lord, add in. বলে রাহুল ব্রেক চাইছে সফট কপি চাইছে
দিয়ে দিয়েছি সব এই অল্প তোকে আমি হোয়াটসঅ্যাপ করে দিচ্ছি রাহুলকে দিয়ে দিয়েছি
Affidavit of service. Deeply.
there is one Passover matter item 14 is the petitioner there না এটা বললাম না রিসেসের আগে নেব
হ্যাঁ ও না এখন হবে না
My lord, I am appearing for the state respondent in this matter led by Advocate General Ashokio Chattopadhyay. Virus has been challenged.
I am appearing for the
It's
petitioner
the
led
matter
by
of
Mr. Ujjwal Rai, Your Lordship. I am appearing for the petitioner led by Mr. Ujjwal Rai, Your Lordship. This matter is related to the compassionate appointment, where the petitioner number 1 made an application for his compassionate appointment, and the application were rejected on the ground that the petitioner is getting family income more than the Group D, Your Lordship.
yes
And kindly see, Your Lordship, the last order dated 14 June 2024.
yes
Your Lordship, the petitioner has already concluded his argument, and
yes
now the state let's see,
but the argument was before some other honorable judge so I release it because it was heard by the honorable judge you can finish your argument over there
no,
what no
and Your Lordship, kindly, Your Lordship, I am praying for time.
from the
but
order
kindly-
dated 14th June 2024
My lord,
passed in the instant
in
matter
this matter, my lord, Mr. Ujjwal Rai is appearing, my lord, leading me, my lord. My lord, what has happened, my lord? The submissions were concluded. Humbly pray, my lord, be placed before your lordships, my lord.
why
My lord, any day, subject to lordships, my lord.
judicial time is to be
No,
wasted
no,
in
no, my
this
lord.
manner
No, my lord. No, my lord.
what no you have made submission that has been concluded
Conclude me, it is there, but my lord, kindly keeps it, my lord, kindly makes it not today or kindly passes it over, my lord, in that event, my lord. I was humbly praying, my lord, because I'm being led by Mr. Rai, my lord.
let your senior come but I make sure that the same order is passed it will be released রাখুন এটাকে ancient matter যাই
Virus
থাকুক
has
আমি
been
করে দেবো
challenged by them. Advocate General is.
all right let me see who is going to appear এটা রাখুন পাস ওভার আমি দেখছি
I'm for the petitioner, my lord. It's a overdall matter, my lord.
হ্যাঁ কি করে চলে এলো পেনশন চলে
Yes, my lord.
yes
Retired on my lord 31st January 2020.
31st of January 2020
Yes, my lord.
28 ডিসেম্বর 2020 তে পিপিও ইস্যু হয়েছে আনন্দ গোপাল and কোথায় অ্যামাউন্ট normal family pension enhanced family pension where is the reduced amount of pension where is the deduction overall
My lord, PPO overdall. My lord, kindly see the in PPO as paid in the page 15.
yes
Gratuity amount is 12 lakhs. And after
Grat-
deduction, he will get the 11 lakhs 177.
oh salary deduction 11 lakh ঠিক আছে আমাদের ইউজুয়াল অর্ডার ওভারড্রল করে দিন ও দেখে দিচ্ছি তাহলে কে ছিল তো, এটা তো হার্ড, এটা হিজ হবে। 28/12/20 sum of rupees from his from her PPO করে দিন। ঠিক আছে, লাস্টে কত পার্সেন্ট দিচ্ছিলাম আমরা? 5% দিচ্ছিলাম। ঠিক আছে, yes, disposed. Disposed.
To 694 in this matter, I beg to appear for the petitioner, my lord. Lord, we try to communicate the learned advocate for the my lord state respondent, but he has not received. Thereafter, my lord, on WhatsApp the communication was there, my lord.
What is the issue?
Issue is that, my lord, the petitioner's husband, teacher of my lord, a school of Purbo Medinipur, he retired in the year, my lord, 1992. It is an extension, my lord. Actually, the superannuation age was, my lord, in the year 1987. His service was approved in the year 1966. Thereafter, retired on 1992. Since then, my lord, no pension has been my lord, issued. No pension.
From 92 to 2026, no pension issued.
Nothing has been issued.
Are you entitled to pension?
Yes, my lord. What happened, my lord? Because the petitioner, my lord, opted, my lord, the contributory provident fund. Subsequently, further, my lord, general provident fund he transferred. Further, my lord, he switched off over, my lord, contributory provident fund. My lord, the withdrawal amount only is, my lord, a meager amount at the 12,000, my lord. It's a, my lord, the stigma in his service career, my lord. But, my lord, the pensionary benefit has not been, my lord.
Did you seek for the pensionary benefit?
Yes, yes, my lord. The, also, my lord, the headmistress of that particular school also, my lord, the sent a letter, my lord, kindly.
There is a legal representation. The petitioner claims to be the widow of a deceased assistant teacher of a school. Stop. She seeks family pension.
Yes, yes.
Stop. A legal representation on behalf of the petitioner.
Yes. This is page 97, my lord. It is 19 January 2022, my lord.
Proof of service. Who did you serve? Director of pension. You did not serve to the DI.
Director of pension, my lord.
Then the letter is also addressed to the director of pension.
Yes, my lord.
And the pension sanctioning authority is the DI. You should have given the letter to the DI.
On the earlier occasion, in the year 2010, my lord, the headmistress of the particular school also, my lord, sent the, my lord, letter to the director of provident fund, my lord. Pension and provident fund.
It cannot be helped if you approach the wrong authority.
So we have made party, my lord.
কি বললাম? Was sent to the director of pension, provident fund and group insurance. It does not appear that the district inspector of schools was approached with the prayer for grant of pension. Step next. In view of the above, the instant writ petition stands disposed of with the observation that it will be open for the petitioner to make comprehensive representation before the concerned district inspector of schools, highlighting her grievances. Step. In the event such a representation is made, the same shall be considered by the district inspector of schools in accordance with law at the earliest, but positively within a period of 12 weeks from the date of submission of the representation. Step. An opportunity of hearing shall be granted to all the necessary parties prior to passing a final order in the matter.
My lord, one document was there in the page 77, my lord, to the director of pension. I'll kindly come to page 77. To DI, my lord, the director of pension, my lord, was, my lord, the grievance of the petitioner was
1993.
Yes, ma'am.
Disposed. What is the matter about?
Matter relates to grant of family pension in favor of my lord unmarried daughter
All right.
of a deceased teacher, but father of the petitioner retired prior to 1981,
Yes.
and
Special bench judgment will follow.
my lord,
Yes.
special bench judgment is follows.
Give me that.
Pursuant to earlier order of this honorable court, my lord, the matter was decided by the Commissioner of School Education, and the Commissioner of School Education rejected the claim of the petitioner, my lord, last annexure, page 37.
Give
Yes.
give the judgment. Give the judgment of the special bench. Ashunto. The
Paragraph 19.
order of the Commissioner of School Education dated 1st February 2022, rejecting the claim of the petitioner for grant of family pension, being the unmarried daughter of a teacher who retired prior to 1st April 1981, is impugned in the instant writ petition. Stop. Now, whether the unmarried daughters of deceased teachers who died prior to introduction of DCRB, 1981 can be allowed or not has been conclusively decided by the special bench of this court in the matter of Purnima. Give. In the matter of State of West Bengal and others versus Shobita Roy. Mat number ta diye neben to. Date ta.
Paragraph 19 it has been.
Date ta এখানে লিখে দেবেন। এটা একটা citation আছে, একটু citation টা দিয়ে দিতে পারলে ভালো হয়। Wherein the court clearly laid down that the benefit of family pension can be extended to unmarried daughter of an employee who died prior to coming into force of DCRB 1981. Stop. Next, 81. In view of the above, the impugned order is liable to be set aside and is accordingly set aside. Stop. The District Inspector of Schools is directed to process the family pension case of the petitioner strictly in accordance with the direction passed by the Honorable Special Bench and ensure that the family pension is disbursed in favor of the petitioner within a period of 16 weeks from the date of communication of this order. Disposed. Service is taken on record.
Since there was delay on the part of the authorities, my lord, some interest on area.
No, this is cancellation of that order. Yes.
96 Mother relate to CPF to GPF area.
I'm appearing for the state, 696.
Date of retired to date of retired.
696. Settled.
Settled.
Where is the PPO? Where is the PPO?
Page 17, my lord.
Acha. You want it?
Date of retirement to 20 September 2014.
Pension from the date following the date of a retirement.
14 আমি রিফান্ড করেছি।
রিফান্ড করেছো? রিটার করেছো
10 থেকে
I could not follow. 2015 you have got the PPO, then you
I just claiming the area pension from the date of retirement, that is 31st May 2010 to the date of refund 20 September 2014.
You refunded the employer's share of contribution.
Yes, my lord.
Challan has been used. Next.
You have handed over a copy over here where you have mentioned that you have refunded the employer's share on 20th of September 14.
My lord,
Where?
on the PPO, my lord, page number 17, kindly see, my lord, the pension WEF 20 September 2014.
Hmm.
That means that day I refund the money.
But then সেটা তো দেখাচ্ছে না
And
এখানে
page
তো পুরো
15 is the
date
treasury
রয়েছে।
challan, my lord.
Page 15
এটা বোঝা যায়
পড়া যাচ্ছে না। Anyway, ওইটা যখন আছে
পরে
তখন
কথা পেন
সেটাই হবে।
বোঝা যাচ্ছে না।
DI Secondary Education South 24 Parganas?
Yes, my lord.
ঠিক আছে তাহলে এই অর্ডারটা করে দাও।
এটা দেখবি তো?
Yes. Next disposed.
97.
697. This is compassionate appointment. Appointment not compassionate ground.
This is not a pension matter?
No.
Yes.
Kindly see the order on 10th May 2024.
I can see that. There was a direction for filing of the compliance report by the state.
Filed, my lord.
No.
Already filed?
That was the report filed. On the basis of the report, this honorable court directed that. That has not been filed.
There is a direction for filing a compliance report. Did you receive the money or not?
No, this is not pension matter. This is appointment on compassionate ground.
Compassionate appointment received?
Has not yet been.
Not given?
This
I
is
have
the
communicated
this is the
twice.
report. A copy.
Copy. ওইটা কপিকার রিপোর্ট।
Original একটাই কপি আছে। Copy, my lord.
কপিকার রিপোর্ট। রিপোর্টটা দেখো। এই রিপোর্টটা আগেকার দিয়েছে তো। This report was filed, already filed.
Already filed, my lord.
On the
Report is there, but this is the compliance report. Where is the original?
Follow up the action and compliance report, let the compliance report.
Where is the original?
On 10th May 2024, I have filed before this court, my lord.
2024, 10 May.
Order was passed on 10th May for filing a compliance. How could you file the compliance on that date? You could not have. There must be an original. Check up.
And that should be filed, my lord, by the joint secretary. That was the
Alright.
direction.
The reports are
And my lord, I have served upon the
taken note.
joint secretary.
Joint secretary.
Then ওটা তো DI করেছে।
What according to you the petitioner is not eligible for compassionate appointment? Why?
No, they said
kindly see the
government order is required to be passed. In absence of any government order, married daughter, they are guided by the previous circulars. But in view of the larger bench decision, Purnima Das,
2009.
You cannot do this. There is a special bench judgment and you have to follow that. There is no alternative.
My lord, kindly
And
see
the special bench judgment has been affirmed by the Supreme Court. What you are saying? I'm not going to accept any such compliance. I'll keep this on record and direct you to file fresh affidavit of compliance annexing the appointment letter.
My lord,
লিখুন তো photocopy of the compliance report.
আরে সেটাই তো করেছে কোর্টার ওটার ভিত্তিতে অর্ডার পাস করেছে এটা দেখো না এটা
Photocopy of the compliance report. Allegedly whether it is affirmed বুঝতে পারছেন বুঝতে তো পারছি না allegedly prepared by the Joint Secretary School Education Department on 4th July 2024. Filed in court today by the learned advocate representing the state respondents is taken on record. The matter relates to grant of compassionate appointment to the unmarried daughter.
Married daughter.
Married daughter to a married daughter of a deceased school teacher. Stop. The issue in question has been conclusively decided by the special bench of this court in the matter of Purnima Das as recorded in the order of this court dated 10th May 2024. Stop. The Joint Secretary is directed to file a further compliance report annexing copy of the annexing documents to show steps taken by the authority to provide appointment on compassionate ground to the petitioner. Stop. Such compliance report shall be prepared and circulated. When did the employee die?
That long before. Well, this is the fifth round litigation. One after
Acha.
another.
Prepared and circulated by 4 weeks. আজকে হচ্ছে 7 তারিখ তো তার মানে যারা list the matter on 24th of February 2026. 698.
698 I appear publicated.
What is the matter about pension?
Yes, pension. The only problem, well, I retired from the service on 31st March 2022. But there is a dispute regarding house rent allowance, and the separate writ application was filed that is also pending. As the pending that house rent allowance dispute is pending, the entire pension benefit has been withheld.
Provisional pension has also not been
Nothing
given.
has been
Gratuity also not been paid.
Only PF was released.
Provident fund released.
Other benefit has not been released.
Yes, respondents.
My lord, there is last order, my lord. There is a direction that my lord, the another writ petition 25604 W of 2028. That is required to be taken up for hearing, my lord, first. No, my lord, this order dated 24th April 2020.
আসুন তো দেখি।
Entitled to get, my lord, the provisional pension.
The department is directed to forthwith transmit records of WPA 25604 of 2018. Within bracket Shantanu Adok versus State of West Bengal and others. Stop both the matters to appear in the list together on 28th of January 2026. এটাকে আনিয়ে নিন।
8th of January.
Next.
Next.
ঠিক আছে, অসুবিধা কি?
699.
Next matter is a pension matter, retired 2022. Nothing has been paid except provident fund amount. What has happened, my lord? The disciplinary proceeding was initiated. I prepared an appeal before the appellate authority, and board passed an order, page 25.
Respondent number 3. Who is the respondent number 3? The DI.
My lord, the report was called for, my lord, on last.
Yes. Where is the report?
My lord, after that, on 3rd of May 2024, this report was. And the up-to-date report is not available with me, my lord.
And I have challenged
At that time, this report was filed.
Now, my lord, this surprising thing, this order was challenged by the school authority. This in 2000. Now,
which order?
This order of the board was
Order of the board.
page 25 was challenged by the school authority. Same was dismissed for default, thereafter rest. Now it became infractuous because I have retired from the service. They cannot proceed with the disciplinary proceedings.
Yes.
2022, I retired from the service.
Right.
So, my lord, now the
Give
payment should be made.
Give the number. Give the number. Acha, the petitioner is a retired school teacher. Stop. He has not been paid.
Non-teaching staff.
Acha, retired non-teaching staff of a school. Stop. He has not been paid his terminal dues because of pendency of a disciplinary proceeding against him. Stop paragraph. It appears that an order was passed by the West Bengal Board of Secondary Education, which was challenged by the school by filing WPA 16799 2011. 2011? Acha. Stop. Let WPA 16799/2011 be tagged along with the instant writ petition. Stop. The department is directed to forthwith transmit records of the said case. Released 28th of January. report.
Gratuity amount.
All right.
The report it
Report
says-
of the District Inspector of Schools, Secondary Education, Howrah, dated 3rd May 2024.
My lord.
Handed over in court today by the learned advocate representing the state respondents be retained with the records.
Copy be
Says that the pension file was not complete, and that's why it could not be processed. At the bottom, my lord, page number 2.
Yes. Let a further report by the DI.
My lord.
Further updated report by the DI be placed before this court on the adjourned date.
Copy of the report, ma'am.
The copy of the report be circulated.
8 to 8. All right, 29. 29.
আরে কি বলছে রিপোর্ট একটা কপি দাও আমাদেরকে
Report, copy of
Copy, circulate. Please circulate. 700.
Time for the petitioner, madam. Yes, this is a pension matter. Madam, the petitioner retired on 31st January 2023. Thereafter, nothing was disbursed in favor of the petitioner, madam. Madam, the earlier occasion when the matter was taken up, madam, there was an allegation that the
Serious allegation.
yes, madam, but no FIR is pending against the petitioner. No disciplinary proceeding is pending against the petitioners.
There was a direction for making the teacher in charge as a party here.
That is not, my lord, supplied us, my lord. The where the teacher erstwhile teacher in charge posted, my lord, that information ought to given to me by the DI. That information is not provided, my lord.
Do one thing. I'll adjourn the matter for the day. You please intimate the State Council and the School Authorities Council so that these information can come in. Please come.
Yes, your lord.
None appears on behalf of the respondents. Stop. Let notice be served upon the learned advocate representing the respondents, intimating that the matter will appear in the list on next Budvar. Next Budvar. 14th.
Yes, your lord.
Stop. The learned advocate representing the District Inspector of Schools shall apprise the court regarding the present posting of the teacher in charge or erstwhile teacher in charge, so that she may be added as party respondent in the instant writ petition. Next.
My lord, madam, I am for the petitioner. This is also the ex-headmaster of a school, my lord. He has retired on in 31st January 2023. But till date, no retirement benefit has been, no PPO has been issued by in spite of the direction of this court, that the commissioner.
What is your stand?
As per report of the commissioner of the school.
Did you give a copy to him? You got a copy?
School authority has not submitted the pension paper, my lord. So, my lord.
What steps are you taking? You are the DI. 1 minute. You are the DI. Will you not take any steps if the teacher doesn't receive his pension?
Kindly, sir.
My lord, kindly see my page 30 only. On page.
I'll kindly see the
Please come.
page, my lord.
The petitioner retired from service on attaining his age of superannuation on 31st of January 2023. Stop. He has not received his terminal dues. Stop. From the report filed by the Commissioner of School Education, signed on 6th September 2024, it appears that the pension case of the petitioner could not be processed as all papers were not received from the head of the institution where the petitioner was serving. Stop. The District Inspector of Schools, within bracket Secondary Education, Purva Mendipur, is directed to take immediate steps to collect the papers of the petitioner from the school where he was serving and take all efforts to make the pension file of the petitioner ready so that the petitioner is paid his terminal dues without any further delay. Stop. The school authority is directed to cooperate with the District Inspector of Schools for the purpose of preparation and finalization of the pension file of the petitioner. Stop. The matter is made returnable on 24th February 2026. Stop. An updated report from the District Inspector of Schools shall be placed before this court on the adjourned date. Call the passover matter.
This matter, my lord.
14. 692.
My apologies, my apologies, my lord. I could not, my lord, be present on the time when the matter was taken. But this is with respect to a compassion appointment. My lord, I will be just beseeching your lordship. I'll just make some submission about
No,
this.
please don't.
My lord,
You have already concluded your arguments before another judge.
that is already long back, and the
So
honorable
what?
court and the honorable court is right now, my lord, sitting with the honorable in the honorable division bench. It's very unlikely that the matter would be taken up. I'll just request you, because many new judgments are there after this, my lord. I will anyways, my lord, require to make my submission afresh. If I request your lordship, it could be taken up subject to your lordship's convenience at any time. I'll just once again, my lord, request your lordship. And anyways, I'll have to make fresh submissions to the any honorable courts, my lord.
No, see, when one honorable judge has heard the matter extensively and you concluded your arguments, the additional government pleader was to make submission at this stage. It is not proper for somebody else to hear it afresh.
I'll just request your lordship, because it was not made a part-heard matter, my lord. Subject
May
otherwise.
not be. It was substantially hard.
Kindly, my lord, sees the predicament of us, my lord, that the honorable court is right now sitting in a division bench. So, my lord, I'll just request your lordship, after this, my lord, these judgment.
Not today.
Grateful.
Give the other matter.
Grateful, my lord. Grateful.
Passover matter. But I appear on behalf of the petitioner, my lord.
Yes. Who was?
My lord, I am appeared on behalf of the state, my lord. Just now I have received the status report through email.
Give a copy to him.
Yes.
What does it say? School? There is no vacancy in the district of Purva Mendipur. How many vacancies are there? 151.
20.
Moreover, it is humbly reported that 151 number of posts of clerk in different institutions are lying vacant in terms of the order of the Supreme Court.
That may be because
Assuming there are 20,
2016 selection.
assuming there are 20, can't the petitioner be accommodated somewhere? Huh? What does the petitioner pay? Is this compassionate appointment or what?
Yes, compassionate appointment. This is the third round litigation.
Then
Father,
take
unfortunately,
steps.
first time due to blood cancer.
Um,
No, my lord,
from the District Inspector of Schools.
to, my lord, process it. My lord, last,
Process it.
No, my lord, I had the instruction that we are, my lord, in dearth of, my lord, vacancies. Now the board.
Now vacancy is there.
Let me take instruction whether, my lord, they have already received or, and, my lord, these are the suitable vacancies where this petitioner can be accommodated. That instruction.
The vacancy statement forwarded by the District Inspector of Schools, Secondary Education, Purva Mendipur, signed on 7th January 2026, filed in court today, is taken on record. Stop. It appears that there are several vacancies in the post of clerk in different institutions under the Purva Mendipur district. Not under, in the district of Purva Mendipur. Stop. The petitioner seeks compassionate appointment. Stop. The West Bengal Central School Service Commission is regional.
Western region.
Achha, the Regional School Service Commission,
Western region.
within bracket Western region, is directed to take prompt necessary steps upon consideration of the vacancy status as handed over in court today. Stop. Release the matter on 29th of January 2026. Stop. An updated report from the commission shall be placed before this court on the adjourned date.
My lord, copies of the statement may be.
Certainly.
Board says more than 80 vacancy probably.
82.
Listen, over here it is mentioned 151 vacancies plus 20. 171 vacancies.
About 200.
39% lordship panel had been prepared, 39%.
Who are you? Where from are you coming?
I am appearing on behalf of the council.
Now,
Similar matter is pending before.
to get benefit.
The issue appointment, still now I am not getting appointment on in the post of group in a vacancy and not be there.
So he is more interest.
Before it lordship, you have cost and issue appointment.
identical matter, kindly takes up 3 first.
All right. Dilip Burman.
First of it.
Yes.
Now, my lord, just kindly have a look to this order passed by this court. Page 34.
8th of July 25.
8th of July 2025.
Hmm.
And my lord, after observing, the court has specifically directed that the internal page 4, having heard the learned advocates appearing on behalf of the respective parties and having considered the material on record, this court is of the view that since the petitioner has already approached the respondent authorities, the chairman of West Bengal School Service Commission, as well as the school seeking extension of the time for joining within the period during the which the recommendation was valid, it would be proper at this stage to direct the chairman of West Bengal Central School Service Commission to consider the representation made by the petitioner, that is the representation dated December 28, 2024, at page 30 of the writ petition, dated on February 17, 2025, 31 writ petition, both addressed to the chairman and dispose of the same in the light of the judgment of the Honorable Court being WP number 2380 of the referred to herein above. The said chairman shall pass a reasoned order and take a decision in the matter strictly in accordance with the law, while noting of the aforesaid judgment, as also fact of the West Bengal School Service Commission has itself extended the validity of the several candidates, as would be apparent from the notice dated March 8, 2025. This past chairman communication. Thereafter, my lord, just kindly see the decision of the chairman, page 40.
Yes.
The operating portions in view of middle portions of the page 40.
Yes.
In view of the said provision, recommendation letter is valid for 90 days from the date of its issuance. A candidate who is unable to join within the validity period of 90 days may intimate the commission for extension of the validity of the recommendation letter. On receipt of such intimation, the commissioner may extend the validity of further period not exceeding 60 days as per the provision to Rule 73 extension of the validity.
What is the date of the recommendation?
Recommendation date was page 26, 22nd November 2024.
All right.
1
minute. Dr. Patro, yesterday, 27th November 24, same order has been passed, isn't it? Yesterday,
Yes.
same date of recommendation, right?
Lordship, I represent the state in this matter, Lordship.
All right. Can same order be passed after filling up of 1, 2, 4, 2 vacancies?
No.
There was a direction upon the commission to file a report.
Yes.
That has not been done.
All
But
right.
in view of the orders which has been passed by the court, if that order is passed, there is no difficulty because we have accepted them. I have also brought.
That will not.
My unfortunate part on my the lack of my clients. My client moved the petitions along with this. I'm handing over the judgments. The 6 persons were included in the petition. 2 of them, as it resides in North Bengal, I have been directed to place the matter up to withdrawal before the circuit bench. Circuit bench passed an order of considerations. Other 4 persons, the Justice Bhattacharya passed an order directing them to issue the recommendation, and recommendation they have accepted that order.
No, but then if assuming you press upon the judgment that you are relying on here,
yes,
then that was passed on 20th of August 25. Now this order, page 34, was passed in July 25. Right. So this came earlier.
Yes.
For consideration.
Yes.
Now it has been considered and it has been rejected. Then what is to be done?
I was submitting before your lordships. The issue is very short. The recommendation was made. Appointment letter was also issued. I could not join within the period of 90 days, although application was made within the 90 days. Then, my lord, and matter referred to the authority by the order of the court with the specific directions. Authority, very mechanical, my lord, they have printed the order. They said, no, you have not applied within 90 days. Your lordship, kindly have a look to this decision, page 41. The appointment letter was given. The present case, your lordship, kindly page 41. In the present case, the petitioner ground for seeking extension was that due to some personal problem, he could not join. The petitioner therefore informed about his inability to join after 133 days. I have joined within I have intimated within 90 days. Your lordship, kindly have a look to this letter specifically mentioned by the coordinate court. Letter dated 28/12/2024. How can it be 133 days? They have not applied their mind also. Your lordship, kindly have a look, page 30.
Yes.
And this letter addressed to the chairman on 28 December 2024. The recommendation made 26 November 2024. Within the 90 days, this was given on court. Consider the matter. Court said you specifically, that letter specifically it was
Listen,
mentioned.
very well. Assuming that the you applied within the validity period
Yes.
and the court took note of that, the court directed them to consider.
Yes.
That has been rejected. Now it has to be see whether the rejection is proper or not. If you say the rejection is not proper, in that case, I'll set it aside and remand it back for reconsideration. Will it serve your purpose? It won't. Same fate will be there. Right. Now, the judgment in
I was submitting
the judgment in the matter of
this court, two judgments of this court. On that same point, if your lordships kindly have a look to this order passed by Justice Bhattacharya.
Yes.
Judgment dated 20th August 2020. May I please stop?
No, there is no requirement. I have read it.
Yeah.
See the last portion, page 15, paragraph 8.
Yes.
Issue needs to be decided.
Needs to be decided. Taking note of the fact that petitioner lost job after being appointed as assistant teacher on being selected, same. It is also first assessment. It is also found that it is within the domain of the concerned authority of the commission to extend the validity recommendation beyond the period of 90 days for a further 60 days. But in the present case, nothing is found that the decisions have been taken on the application made by the petitioner seeking extension of the validity of the recommendation. As a special case where it is found that the petitioner lost their job in terms of the judgment of the Honorable Supreme Court, such and such, taking note that the petitioner approached the chairman of the commission on seeking extension of the validity of the recommendation within the period of 90 days from the date of recommendation. Concerned authority of the commission is directed to extend the validity of the recommendation of the petitioner for a period of 60 days from the date and permit the petitioner to join the post of the assistant teacher in recommended. Necessary orders are to be passed by the
So the
commission
court considered this as a special case.
No. Special case is Boisaki Bhattacharya. My case is also Boisaki Bhattacharya. We have lost their job.
All candidates who were issued appointment letters but did not join, it is only because they had a job in their hand.
Exactly, that is their case.
Right.
Yes.
But then why will a mandatory order of recommendation extending the period of recommendation be issued?
Because of the fact, my lord, the court considered the matter, it is not a normal case. After the Boisaki Bhattacharya, they lost their job. And we have also the same, that we are the candidate of the
I understand, but there are other matters pending where the commission has already filed an affidavit and disclosed that 1242 seats are to be.
That is before the appeal court, I argue. That is
You argue it is all right.
different. That is the case is the completely different. Their recommendation was not made. Vacancy was there. Whether the recommendation can be made, that is the subject matter of the challenge. Whether I can avail that opportunity, the commission can recommend our case in spite of the available vacancy. Then division bench said yes, if the vacancies are there, you within the certain vacancy, possibly one.
1242 vacancies.
1242. Then you
Yes.
recommend.
Right.
In that case, recommendation was done and appointment letter was issued and court passed an interim order restraining them not to fill up the post. and the post is still lying vacant. So show my
Now, still lying vacant, is it only for you?
Yes.
Where is that?
But your lordships can see the three repetition, 3 orders.
Show me.
No, interim order was passed.
Oh.
And you're restraining them from filling up the post in postal if it is not already. We have definitely already. Yes. If has not been filled up.
See, the court records that the recommendation has lapsed for the reasons cannot be attributed to the petitioner.
Yes.
I do not know how, because it is you who did not act in accordance with the recommendation. You sought for extension, that is different, but it lapsed because of your fault.
Yes. Then your lordships can see the.
For a period of 2 months, long over.
No.
Oh, acha, November 25. If it has not been filled up.
Yes, it has not been filled up. This 3 posts, it is kept pending.
All
It has
right.
not been filled up. I have definitely instruction. Your lordships can take information from the state house.
Yes. What will be your submission?
And others, my lord, the P.S. বিশ্বাস case. The Justice Dutt case, if your lordships kindly have a look. Okay. And sir. The operating portion will be para 7.
Yes.
Furthermore, it cannot be lost sight of that regional commission has no right to do away with the name of the internal candidates who has been recommended without any of the 4 events mentioned in the clause A to D of the sub-rule 5 happenings. Here, although the petitioners, while praying for extension of time to join by letter dated 21st November 2013, did not in so many words express that the offer of the appointment was being accepted by him. The petitioner did not either show any sign of refusal to accept the appointment offered to him. On the contrary, his intention was clear. He wanted to discharge his responsibility as a teacher of his workplace, thereupon to join the schools. Rather than this is being considered as an unusual state, he appears to be perfectly justified in his approach. That apart, they never be statement of the fact. Thus, the question of doing away his name from the panel does not and cannot arise. It could never, however, have been intention of the framers of the rule that a candidate would find himself in a precarious situation where he is unable to join despite the recommendation issued in favor of suggesting that despite his name figuring in the panel. If the statute had to provide a specific time limit for joining and the consequence of non-joining, it would require serious consideration as to whether such time limit ought to be constituted as disease and infectible or not. The statute being the silent on this point, it has to be held that an appointing authority has no right to insist for joining within the stipulated period, and if within the validity of the recommendation request is received for extension of the joining time, such request cannot be found only on the ground expiry of the period of the stipulated in the date of the appointment. Acceptance of the argument of the council for the respondent number 7 and 8 would encourage unscrupulous people to take advantage of the slip in the 2007 rules, if not making provision that in the appropriate case doing of the validity of the recommendation made by a regional commission, joining them may be extended to corruption to achieve vested interest and through the system of the appointment candidates through the machinery process and the act out of here. For the opposite, refusal of the respondent of 7 and 8 to allow the petitioner to respond. So, although this is the 2007 rules, but the rules are same. The recommendation validity, such as that the appointment letter was offered, I could not join, therefore extension was made.
In this case, the letter of appointment was issued. For-
My case letter of appointment was given.
Given.
Yes.
Recommendation was there.
Page 27. Letter of appointment.
স্কুল চাইবে স্কুল অলরেডি ইয়ার করেছে এক্সটেনশনের জন্য পেজ 30 এই যে also paid for extension page 30
And school also paid for extension. Page 33.
School never prayed for extension. School sought for steps.
Yes. Submitted a prayer to the head of the institution for joining the said post. Now, on the basis of the prayers, I am sending the necessary documents for taking necessary action for issuing subsequent recommendation letter if possible.
All right. Yes, the commission. What about the 1424 seats?
Yes, that will be heard on the 15th.
What is to be heard? You all are taking steps to fill it up.
We have taken steps. We have coordinated with the education department. They are supposed to be giving us the vacancies. The moment the vacancies are given to us, we will be.
And are the vacancies which are mentioned over here in this order directed not to be filled up? Vacancies are.
That cannot be, my lord. It is the separate issue. The recommendation was made. There are no recommendation available in spite of available vacancy, no appointment, no recommendation. That was the issue.
21st of
This
November.
relates to the first phase of counseling. After that, there were 7 more phases of counseling. Whether that vacancy got utilized in the subsequent 7 phases of counseling, that has to be checked.
There was a direction upon you to file a report.
Yes, that has not been done.
And because the court has passed an interim order to not to fill up the post if not filled up.
Not filled up. So the date wise, I will have to check whether it
Yes,
was.
whether the vacancy is still there or not.
Yes. Let me come back with the instruction.
When will you prepare the report and specific instruction as to whether the vacancy has been filled up or not?
Yes, that I can take that.
Please come. The petitioner prays for extension of the time period of the recommendation letter, which expired nearly a year back. Not year, 2 years back. Stop. It appears that video order dated 21st November 2025, this court directed the commission to file a report. Stop. An interim order was passed restraining the commission from filling up the post in question for a period of 2 months from date, comma, if not already filled. Stop. The report has not been filed till date. The report by the commission has not been filed till date. Stop. The interim order is subsisting. Stop. Next. On the prayer of the learned advocate representing the commission, time to file the report stands extended till how many days?
2 weeks. 3 matters are there.
Yes. 2 weeks. All right, 22nd of January 2026. Stop. List the matter on 16th February 2026. Do one thing. 22 বললাম তো, make it 28. 28th of January. ঠিক আছে? 16th returnable. It will be open for the petitioner to file exception to the report prior to the adjourned date. Stop. The interim order that is subsisting in the matter stands extended till 6th March 2026 or until further order, whichever is earlier.
Lordship, the state is represented in all three matters, Lordship.
13th of February. It is a Friday. আচ্ছা ঠিক আছে রাখুন. Let us see. 13th. Keep it on 13th. Same order will go down in 2,
1, 2, and 3, Lordship.
1 and
All
2.
the three.
Who's for the state in those matters?
I am there.
You are there. Record
Lordship.
appearance.
Sir, phone. My lord, I am for the petitioner. This matter pertains
Grateful,
to
Lordship.
answer key and question of SLST. Monday evening, I received the report. I will be filing an exception. 7 days time, almost ready, my lord. 7 days time may be given. I can
I'm
complete.
appealing for the commission, my lord. The report is ready. One of my colleagues will file it.
Received Monday evening, my lord. I'll almost ready, my lord. 7 days time may be given. I can affirm and submit.
The report by the commission filed in court today is taken on record. Stop. Learned advocate representing the petitioner seeks time to file exception to the same. Stop. Let exception be prepared and circulated by 19th of January. Released on 10th of February.
Very well, my lord. Grateful to lordship.
Grateful, my lord.
Lord, I appear for the added respondents.
Where is the petitioner?
The only reason today it is in the list that yesterday submission was made that this is probably a different matter because all other matters were lordship kept on a separate date. So that was the purpose. The lordship said then let it be next day.
Lord, it was
Yes.
Lord, it was submitted that the panel, the detailed tainted list has not been published as per your lordship's order dated 19th of November. But kindly takes your lordship's order dated 19th of November, my lord.
Yes, your lordship.
Lord,
Yes.
Lord, from paragraph 31 onwards, my lord, your lordship will, my lord, it was alleged that the tainted list which was published by the commission was not a detailed one, and the details of candidate cannot be deciphered from the tainted list, only from the roll number and names. So your lordship was pleased to direct the commission to publish a tainted list with other details like father's name, subject, etc. You know, that list has been published in the public domain on 9th of December. List contains of this same 1806 names which were published earlier. Now the petitioners on the next occasion, and in paragraph 14, 4 tainted names were given that those people were in the verification list. So out of those 4, 2 of them belong to the physical handicap category, which your lordship decided that they also come within the purview of tainted, and that view has been upheld by the Honorable Supreme Court. Thereafter, we have removed 269 additional candidates of PH category via subsequent notification. We have disclosed that as well on 28th of November. I am led by Mr. Bhattacharya. He is present in. So, those lists have been published in the public domain. On the last day, paragraph 37 of Supreme Court's order on 10th of December was shown to your lordship, saying that there are several candidates who received appointment without any recommendation. Excess appointment issue was raised, accordingly, your lordship directed us to produce the list of those candidates, the commission and the board to produce the list of those candidates who received appointment in excess of recommendation. But Mr. Bhattacharya, I have instructed my.
We have, after your lordship's intervention, on 10th of December, your lordship's order kindly cease. Paragraph 3 and 4.
Yes.
This is 10th of December. Now, on the 9th of December, we have published a list, incorporating 1806 candidates. That list is perhaps with your lordship.
All right.
That list takes care of all details, father's name, details of candidates, everything.
And these candidates who were appointed with OMR score mismatch?
Everything is
those
incorporated
names are
there.
also there.
Yes. Now, we have, on instructions, Mr. Singh just now informed me, he has been informed by the chairman of the commission that, apropos your lordship's intervention and the Honorable Supreme Court's order, if a list is in the pipeline, it is going to be published any day, in this week, maybe tomorrow or day after, latest by Friday, containing, if any balance is left out,
Balance information with regard to the candidates.
if it is left out, we will be publishing that list. If anyone is detected, he will be asked to leave from the selection process. If anyone's name figure in that list, it is approximately a 200 candidate list is going to come out. That list, on instructions, oral instructions, if your lordship desires, we'll come back on Tuesday with that list. But, your lordship may, on instructions, record this submission on behalf of the commission, that, a list is going a further list is going to come out, containing all, because that list is there. The chairman, to make it very, comprehensive and, so that it is, absolutely, free from anything, he is personally looking into it so as to obviate any chances of any further allegations being made.
All right. Let me hear what the grievance of the petitioner is.
First,
Are you aware that the list has been published?
What list they have published, I just want to hand it over and kindly see what my learned friend submission and apropos what is the list prepared by the West Bengal Central School Service and what is my prayer and what is the content of this writ petition. Before that, I want to demonstrate that the Supreme Court order. What was the Supreme Court order? By referring this particular writ petition, why the Supreme Court returned back all the issues before this court due to this writ petition, and specifically this writ petition number was quoted. That's why, my lord, I want to refer that, my lord. Kindly see that order, that is Vivek Pariya order, my lord. I believe, my lord.
Yes, it's here.
Yes, my lord. I want to read it, my lord. In the first page of the ordering portion, the last paragraph, we are informed that a writ petition being WP number 26288 of 2025, that is this instant writ petition, has been entertained by learned judge of the High Court at Calcutta, and various issues were flagged by the learned judge in her order dated. 4 order dates was quoted. One is 7th November, another one is 11th November, another one is 12th November, and another one is 19th November. What was the 19th November, my lord's order? Kindly take my lord's 19th November order, my lord.
Yes.
And thereafter, my lord, I came with prayer and what apropos, what is the submission? Para 35, page 10 of my lord's 19th November 2025 order, my lord. Para 35. The commission accordingly ought to publish a complete list of tainted candidate with proper and appropriate details for the purpose of identification. The aforesaid publication ought to be made for maintaining fairness and transparency in the selection process. Such list will also come to the aid of other competing candidate to draw the attention of the commission in respect of any ineligible candidate who may appear in the test. Para 36, the very next paragraph. The commission is accordingly
to forthwith publish a complete list of tainted candidates in the manner as mentioned herein above. Take necessary step against the tainted candidate mentioned in paragraph 14 of the writ petition who appeared in the selection test. So there is twofold direction. One is that in paragraph 14, whosoever I identified, the writ petitioner identified as a tainted candidate, they left out, they ousted out. That is one thing. Another thing is the complete.
All four.
They can say so, but I have no instruction in this regard. But what is the complete list of tainted candidate? Who are the tainted candidate and whose oustment I want, my lord? Kindly see my prayer portion. Paragraph, sorry, prayer G. A writ of and oblique or in the nature of mandamus directed the respondent and their agent, servant, subordinate, employees, and oblique or assignee, and each of them to publish name of all tainted candidates, including the candidates who got appointment after expiry of the panel, rank jump, and other categories. Well, that kind of list which they publish. From that list, is it evident that who fall under which category? Because in Supreme Court judgment, well, Supreme Court parent judgment, what was the, that is
list of my lord ke din to.
Yes, it is.
Yes,
The entire list.
Is it the same list?
1806.
Yes.
But I should say only one thing.
Only one thing, Milad.
I just complete my submission. I believe.
No, I mean.
Complete my submission.
Possibly my learned friend is entering into the issue.
Disputed question whether the candidates appointed after expiry of the panel.
Only one thing. Only one thing, Milord. Mr. Shamim will make his submissions only one thing. Milord, in terms of 19th November order, whatever was obligatory on our part, we have published a list on the 9th. That list officially, Milord, we have handed it over. Not by way of any affidavit, neither has he filed an affidavit.
No, because you have published it in the.
Yes, it's a public document now. Now, Milord, in the absence of a collateral challenge to the names as to which whatever is.
He's not challenging.
No, I'm not challenging.
He's not challenging.
Kindly give my submission that.
Yes.
Very well. Kindly take that the parent judgment that is para 24 onwards, my lord. That is part 3.
Which page do I get that?
Page number 28 of 41, para 24 of the parent judgment. That is part of the judgment. Oishaki Bhattacharya.
Page number 28.
28, para 24. No, yes.
No. Give me the page number, proper page number. Para 28, I'll get it. Paragraph, wait. Paragraph 28. Yes.
What is, my lord? Paragraph 24.
Yes.
28. Where, my lord, the issue that, my lord, the impugn judgment refers to the following statistics report submitted by the WBSS before the High Court.
Yes.
Here, my lord, they categorize OMR issue, rank. This is the number of all narrated by the WSS. Now, my lord, para 25. In the written submission filed on behalf of the WSSC in the court, 2 tables has been furnished.
এটা কোন অর্ডারটা ভাই একটু বলবে?
Can say the mother order.
Mother.
Yes.
ঠিক আছে বলে।
In the written submission filed on behalf of the WBSSC in this court, 2 tables have been furnished. Table 1 pertains to candidates who either jumped rank or were appointed despite not being in panel. Their details are as under. These 2 tables is very important. Why I say so, Malad? Because not only the expiry panel is not the only question. The second question, another question is cropped up. By showing these 2 tables, I will, Malad, address this one. Table 1. Assistant teacher for classes 9-10, rank jump 74, out of panel, but still appointed 111, summing up, that is summation of that to 185. Assistant teacher 11, 12, 20 plus 18, that is 13. I just left out for the time being for group C and group. Now, we have table 2. Table 2 furnished by WBSSC is for candidates who are appointed by manipulating the OMR sheet. Table 2, who the by manipulation, this is manipulation, clearly mentioned. Table 2 is as under.
Para 25.
Now table 2, category A, assistant teacher, classes 9 and 10. Number of candidates with alleged OMR score mismatch as per CBI image 952. So 952 candidates, they are manipulated candidates. Out of that 952, 808 is got appointment. So remaining candidates, whether they are tented or not specifically tented, or not tented or untented, whether out of that someone is in the list or not. What I gathered from their submission, who only got appointment, they are only tented. But here were clearly mentioned, they are manipulating candidate, manipulating OMR, which was 952. Might be, suppose, I give an example. Suppose the candidate, because it is a multi-layered selection process. First OMR sheet, that is written examination.
No, I have followed. I have followed.
So
I have followed your submission.
Whosoever not get appointment, that details. And another example of that, Malad, that whosoever not got appointment, but in manipulation list, there is a candidate who calling in that. One Priyanka Pal, that such type of candidate. So my contention is that they ought to publish that details, candidate names, roll number, and fall on under which category. They ought to mention number one. Number two is that regarding the expiry panel. Yes, that is mentioned in para 31. For the time being, because that matter is on the 13, my lord. Now, my lord, my point is that, my lord, there is two important aspects involved in this matter. One is that whether whosoever after second round of counseling got appointment, whether he would be treated as a tented candidate or not, that is one aspect in this matter. Another aspect is that, my lord, who not get appointment but manipulated. Whether
yes, this table 2,
table 2 says
952 candidates have been found to have OMR mismatch as per CBI image, but out of 952, 808 is appointed. Right?
So remaining candidates, they are also tented candidates. So they, in this selection process, they are already called in interview. So whether they will treated as a tented candidate or untented candidate, as per their understanding, first what they did, they tried.
All right, you have flagged the issue. I'll take care. Next, what is the issue?
These two issues. My first point is that they just only considered whoso got appointment, they only considered as a tented candidate. All right. Is the expiry panel. So for the time being, I have threefold prayer. First is that they ought to publish the full tented list, including the expiry panel, including the tented candidate who not got appointment but OMR manipulation or other manipulation. Second thing is that, my lord, they ought to give all details. All details means name, other's name, school, which district, why? Because of that. Reason is that, my lord, in the main judgment, there is a specific direction order of the petition bench, which is upheld by the Supreme Court, that they ought to return back the money. So all details is necessary because initially they recommended by the SSC, thereafter they appointed by the board. So all details are necessary. Second thing is that, my lord, you remember in the last occasion, my lord, I canvassed that the excess appointment. So they ought to take care of that, the excess appointment. For that reason, who are that excess appointees? For that reason, they
this is panel. This is table 1, page 29. You read out of panel, but still appointed. That is excess.
That is not the excess appointment, my lord.
Which
para 37.
37.
Supreme Court judgment.
All right.
Married.
Number of candidates recommended for appointment and number of candidates where appointment letter is issued. All right, paragraph 37.
37. May I read,
Hmm.
madam?
No, I've read it.
Yes. So, madam, for the assessment of excess appointment, they ought to sit with the board because they ought to tally it. Suppose, madam, I don't want, madam, anything which is, madam, beyond record. No. Suppose, madam, there might be a re-recommendation because wrong recommendation. There might not be, but Supreme Court in para 37 narrated by gathering their data, their affidavit, because in this proceeding, my lord, several affidavit is there. If my lords want, I can place it in this whole proceeding because this is the culmination of every data. So Supreme Court says this is an excess appointment by comparing their own data, that is board data as well as SSC's data. So whosoever the excess appointees, they ought to also canvass it. So for that reason, they ought to sit with that another Article 12 authority, that is board. So that is the second thing. And third thing is that, my lord, after that, because in the new selection process, what is my endeavor? My endeavor is that in the second SLST 2025, not a single tainted candidate not entered in this process. But what happened, Malan, in this process? Because I narrated in that education matter, which is rule is under challenge. In that matter, what happened, Malan? Suppose a candidate is tainted in 910 category in English subject. Now he have MA degree. Now he, in this selection process, he participate in the 11-12 category as an education in an education subject with his or her MA degree, and he participate. Although he or she is a tainted candidate, he participate in the education subject, and now he
called for interview.
So, my lord, for that reason, the all details is necessary for the tainted list as well as the interview list. Otherwise, my lord, in another subject, tainted candidate sat in another category, another subject, and my lord got appointment. So this threefold prayer for the time being, and I believe, my lord, this have substance.
All right.
Well, I have a very small submission so that I make my stand clear. As far as any corrupt candidate, whether appointed or not appointed, I have nothing to say because I'm not. My only submission is that interpretation that who are tainted, whether A is tainted, B is tainted, or Z is tainted. Assume A and B clearly clarified, there is no confusion. Maybe after expiry, that is Lordship is hearing the matter. As far as that is not disturbed, I have got absolutely nothing to say.
Very well. Commission.
But just one sentence, since my lord, I am also appearing. My lord, Lordships has enough power. They lost their job after 6-7 years. So it is not a case that this has to be done just now. Why I'm saying this? Because the last order, my learned friend has referred about the earlier orders. Last order, there is somewhat an indication that finality, because
all right, I followed it. Yes, Commission, the list that you handed over in court today contains the names of 1806 candidates. The Supreme Court's order that has been read out just now.
Your Lordship is referring to me, paragraph?
Paragraph 25, 3rd April's order.
Yes, table 2.
Table 1.
Table 1. In the written submission, Your Lordship, the begins it.
Rank jumped, the middle
yes.
column.
Yes.
Out of panel, but still appointed.
Yes.
Are the names of these candidates, we are concerned only 9, 10, 11, 12, not the CD category. All right. 74, 111. Are their names over here? You will not be able to say.
No, I'll have to come back. Yes.
The reason that you are unable to say means your list is incomplete. List should be such that anybody, any member of the public who sees this would able to relate this list with the Supreme Court's order and get all information. Since you are still in the preparation, a process of preparation of a further list.
Further list, Milord, is that list, Milord, again on further instructions I am saying, Milord, it is that list which the CBI on investigation gathered, whose names might have missed in this 1806. If the CBI has given us certain names, we are going to publish that list only. According to us, persons who were never appointed, that aspect, is they don't fall under the tainted category according to prima facie, I'm saying.
All right, page 29. Same table 1 and table 2 of the same page.
Hello.
Table 2, number of the candidates with alleged OMR score mismatch as per CBI image 952. Have you published the names of 952 candidates?
Prima facie, yes. Because
prima facie, no. Because just now you said the candidates in whose favor appointment letter has not been issued, they have not been taken to be.
Names, appointment letters have not been issued, we have not.
Yes. But then if
their names today find place in the CBI list, we are
the CBI image
we are in the process of updating a further list. We are going to come up with that list in course of this week.
No, that I have followed. Yes. But the numbers 952 as is there in table 2, 907 as is there for classes 11 and 12. All names should be there.
No, just give me 2 minutes.
No, I will not give you any time.
The instructions part.
No. Taking instruction means the list that is there is incomplete.
I won't say it is incomplete, I say, it is strictly in adherence to whatever orders are being passed. If your lordship proposes to add or wants us something to be added to that list, if it we will definitely act in terms of your lordship's solemn order.
Oath's order is for identification of the persons. Will you be able to identify from this list as to which candidate falls under which category?
I think that exercise can be made. I think. Let me just see the instructions. Just give me 1 second.
Well, meantime, to assist the court, my lord, your lordship query was whether those persons' name has been published who have not been appointed. My lord, in one of my writ petition, I have preferred a writ petition, my lord. That person has not been appointed. Sujit Kumar Pal, his name was, my lord. He has been wrongly recommended. He has never approached for appointment. He has not taken the appointment also, but his name is appearing in this 1806 list.
Please come.
Just for that, it is clearly of the court. If I simply add this for this year, because of that.
My instruction is we have published 808. 808, that 808 thing. The remaining 950. We are in the process of publishing the remaining persons. We are in the process of publishing 952. That is first instruction. Second is, this categorization is there, but not in public domain.
Do it. The idea is for identification of candidates.
If it so comments, your lordship will.
Not commences. It is there in the order for the purpose of identification. For the purpose of identification, because the figure that you mentioned is already there in the Supreme Court's order.
Yes, we are going to revisit this 808 names, find place.
But then 952 should be there. Right. Next one also 772 you must have published. It should be 907.
Yes. Insofar as the other thing is, yes.
Right. And page 35, paragraph 37.
Yes, please come to 37. Now, there I think the board has something to say.
What do you have to say?
Kindly seize this paragraph. It is also important to refer to another finding recorded in the impugned judgment regarding discrepancy in the recommendations made by the SSC and the number of appointment letters issued by the board. The investigation revealed the following disparities between the number of candidates recommended for appointment by SSC and the number of appointment letters issued by the board. Their number of candidates recommended by SSC in 910 is 11,425. There is a discrepancy of 1071 excess appointment, and similarly 199 in 1112. Now, my lord, when confronted, the board had proffered that all appointment letters were issued on the recommendations of the SSC. On the other hand, the SSC contradicted the stand of the board by stating that they had not issued recommendation for the excess numbers mentioned by the board. WBSSC and the board now claim that the discrepancy in the number of appointment letters issued is incorrect. The board counted all letters without adjusting for candidates who did not join, while WBSCC excluded those candidates from its recommendations. Therefore, there is no discrepancy for teaching staff, and the small difference for non-teaching is irrelevant, as many of these candidates are already on the tainted list for rank jumping or being out of panel. We reject this late attempt by SSC and the board to reconcile the figures, as the number of recommendations made by SSC is independent of whether a candidate joined the post. I mean, this is the sum and substance. I mean, if I have correctly, understood, what is passing through your lordship's mind, your lordship wants, the persons, who were in excess panel, those persons, apparently in the Supreme Court order, out of panel has not been specifically, earmarked to be tainted. Out of panel or, excess panel. What is there is, OMR, rank jump, everything is there in the Supreme Court judgment. Kindly do not
And
look at
this is what you read is also from the Supreme Court judgment.
Yes.
It is not that you are
Yes,
reading from outside.
but ultimately, the fact remains, persons who were not appointed, those persons, have not been, earmarked to be tainted.
Who is earmarking?
The attempt is, to ensure that in the fresh selection, those persons who were, not appointed,
They do not get a chance.
They should not. That
Yes.
is the attempt.
Right.
Now, in my humble understanding, paragraph 37 has to be reconciled. If that reconciliation, I think, some attempt has been made somewhere,
For reconciliation?
for these figures to match.
And the board?
Yes, I think. I think.
Reconciliation board is not a correct word. It is the data has been matched. When this thing came up, we have filed the differences, my lord. Then the board.
The Supreme Court did not accept your stand, so there is no question of this court accepting it. It cannot be done. I do not know what the data says. The figures are here.
Well, the Supreme Court relied on the data provided by the investigating authority. Well, and kindly have a look at this. I have just prepared a report, Your Lordship. Well, kindly see. And Your Lordship, paragraph 37 of the Supreme Court order. Well, here the court says that the investigating officers, they have said that number of recommendation by SSC is 11425, and appointment given was 12946. But in this, what I have submitted, and this also we have submitted there, we say no. This figure is not correct because we have received recommendation 13056 and we have issued recommendation 13056. It is more than what it is over here. Here they say we have issued appointment 12956. We say no. We have issued more appointments. That is 13056. And we have received more recommendation that is not 11425, but 13056. So, from where this selected, my lord, we don't know, my lord, how it came up because we have.
But these figures were there before the Supreme Court.
Lordship.
The court is not revisiting the figures. Whatever is there is there. If you say that these figures are wrong, go before the Supreme Court, get it corrected. This court is not entering into all those things.
Now, in terms of your lordship's order,
Supreme Court rejected the reconciliation attempt made by the parties and said that whatever the figure is there. Now, I do not know what the figure is.
There is a report at our instance also.
There is no difference. Because what figure is here, our appointment is more than that. And recommendation is more than that. Well, if we have all the data, my lord, we can produce with your lordship the total recommendation and appointment, which is more than the figure given by the agency.
Please see the report which we have filed, in terms of your, this direction. We have filed a report. We have circulated a copy. Please see the report once.
What have you said?
Kindly see. By this writ petition, Mousumi, who participated in the second SLST for the purpose of this petitioner number 1, we have recorded. Now, in paragraph 14 of the writ petition, the allegations made by the writ petitioner have been dealt with. Please see the report once.
No, that
Allegation is a tainted candidate.
You read out physically handicapped candidate.
Yes.
Something.
We have ascertained and we have, weeded them out.
That is a different thing. Paragraph 14, we are not going right now. That it has been mentioned in the report.
Yes, we have weeded them out, apart from only one candidate, Animesh Mohan.
Why?
Because we have found that the during verification it was found that the actual date of birth is this, and candidate was recommended by the commission in 13/9/18 and had completed more than 5 years. Thus, he is entitled to 10 marks.
Entitlement is different, but is he a...
No, not tainted. That was not the allegation.
That was also not the allegation.
His allegation, if I have correctly read it, as per the date of birth, the candidate could not have had 5 years experience and thus could not have received 10 marks. That was the allegation.
All right. And that you found that he had 5 years experience.
Yes.
And you've given the mark.
And also, insofar as Deblina Mondol allegation was a tainted candidate. We have found that the details of this candidate do not match with the tainted candidate with a similar name. Tainted candidate's name is Deblina Mondol, daughter of Anup Mondol, and the date of birth is different.
This is the requirement of giving the name of the father of the candidate.
Now we have given the name of the father.
Yes, but then this is also partial information and not the complete information for the purpose of identification. Please come.
Instead of, your lordship may pass the order. I cannot say anything. Do we really come back on Tuesday and inform as to what is the latest development? Because we are inclined to comply with everything, including publication of a further list as disclosed by the CBI. Those names that have been left out. If your lordship says something,
I will not add anything, whatever is there in the order.
Very
right.
Very well.
And
your lordship only indicates.
I will only keep the
that issue. Who is tainted in what capacity? Your lordship wants us to indicate.
I am making this orally known to you so that you can take steps at the time of preparation of the further panel that you are going to publish, so that these details are also incorporated. Idea is, in the main order, I have mentioned identification of the candidates.
Very well.
For the purpose of identification, whatever is required.
I think, your lordship is audible enough, for Mr. I think, everything will
do it. While signing the order sheets, I see number of candidates, number of advocates named for the commission. So it is expected everybody is hearing what the court is saying. And whether he is audible, court is audible to him, or somebody sitting into your back.
No, court is audible for obvious reasons. There are reasons which cannot be said in open.
Everybody is not anybody, so don't say anything.
The list of 1806 tainted candidates in connection with first SLST within bracket assistant teacher, 2016 examination, handed over by the learned advocate representing the commission in court today. Do I keep it on record? It is already there in the public domain.
No, your lordship keeps it for you.
Is taken on record.
Only another thing, we intend. Only this much. Regarding this difference between appointees and recommended candidates, we have copy the
No, my lord, I have already given.
No, not this one. This is by the commission. Kindly seize this. Copy the copy the petition.
What is this?
Kindly seize this.
It is a note.
Yes. Please see paragraph 2.
Yes.
The fundamental difference between WB, SSC and SSC is that the SSC has to recommend a candidate through a counseling process before a recommendation letter, and while WB, SSC's responsibility is simply to print out an appointment letter once it receives. Now the counseling process involves tens of thousands and thousands of vacancies. In order to generate recommendation letter with all relevant details when a candidate chooses a particular vacancy at start, a program has to be designed. The mechanism involves pairing one candidate with one vacancy through the program, a unique combination which precludes another candidate from being wrongly allotted. Now, it may happen that a candidate who chooses a vacancy at the counseling hall does not join. It is also possible that he later finds out the vacancy is wrong. In the first instance, a vacancy is released which has to be offered during some subsequent round of counseling. Within the lifetime of the panel, if it is chosen by some candidate, then there will be two different candidates and two different appointment letters for one single vacancy. In the some alternative matching vacancy has to be provided from the vacancy data set or sought from the government for the candidate who will have two recommendation letters and two appointment letters. We are mainly concerned here about the first example because WBPSE has provided us a data with name appearing only once. Then we have said that the paragraph 10 yes. I'm sorry, paragraph 7. SSC has to first dealing with the pairing of the previous candidates with the concerned
Listen, this is the mechanism how it is
yes,
worked.
and we have explained these charts also. Please see.
This is a part of my report, Your Lordship.
This please see page after there are two charts here like this. Now please see. Total appointment. This we have explained. The explanation kindly see reported as non-joining and kept in effective or cancelled list and hence not included in this. It may be noted that some may have subsequently joined, but as such were not reported to WBSSC. They were kept cancelled. So this is the factual position.
So this is the mechanism as to how recommendation is made and then appointment gets
11,425 and that reconciliation.
Whatever.
Yes.
This is the usual system.
These two, Your Lordship is correct. These two things, if Your Lordship kindly takes the pains 37 once, paragraph 37 once.
Yes.
And reconciles the figures, Your Lordship will not find the matching figures. 11,425. Just remembers 11,425. Here Your Lordship sees page 4 of whatever I have handed over to my Lord. Please, last page. Please see, total appointment is this. Received recommendation letters from SSC but not received appointment from WBBSE is this. 1A plus 1B is 13,069. Unique name in SSC through counseling is 11,425. That figure 37. Then through court case 95. Rank jumping out of panel is 185. Total this is difference is 1364. Reported, the explanation is reported as non-joining and kept in effective or cancelled list and hence not included in this. It may be noted that the same may be subsequently joined, but as such were not reported to WBSSC. That is the sum and substance today.
134, that is also there in the report, Your Lordship. Kindly see, Your Lordship, the list is there. 1364 difference.
এই লিস্টটা বললাম রেকর্ডে রাখা হলো ঠিক আছে the list discloses the roll number, comma, name, comma, subject, comma, name of the parent, and the date of birth of the candidate. Stop. The list does not disclose the category, for which the candidate was found to be a tainted one. Stop. The details of the school and the district where the candidate was appointed in the first SLST are also not disclosed. Stop. The court in the order dated 19th of November 2025 clearly mentioned that the requirement of publication of the list of tainted candidates is for the purpose of identifying the candidates. Stop. If proper and complete details of the candidates are not disclosed in the list published by the commission, then there are chances that tainted candidates may slip through the net and participate in the fresh recruitment process. Stop. The Honorable Supreme Court made it clear that all efforts shall be taken to ensure that none of the tainted candidates are permitted to slip through in the fresh selections, be it on any pretext. Stop. It has been submitted by the learned advocate representing the commission that steps are being taken for publication of a further list. Stop. The commission shall take note of the observations made herein above and publish the list disclosing all relevant details of the candidates by which they can be properly identified. Stop. Do you want this to be retained with the records board? Do you want
Copies may be circulated too.
a report filed by the West Bengal Board of Secondary Education? Signed by the secretary on 5th January 2026 in court today. Be written with the records. Stop. Let copy of all documents filed in court today be circulated to all the parties. Release the matter for further consideration on 11th February 2026. Commission has enough time. Today we are only on the 7th.
And only one humble request to Mr. Shami. Yesterday he was doing one matter. Suddenly he jumped up that we have not complied. We also at times fall apart when he makes these allegations against us.
This list which you handed over today, are the names of these candidates included in the list that has been filed by the commission? If it is so, then I'll not keep this.
Yes.
Then you can take this back.
Only first 4 pages to demonstrate that part.
আর কি চাইছিস?
হ্যাঁ, কল্যাণ কৃষ্ণ। একত্রিশ থেকে 34 1 মিনিট দেখে নি।
Your lordship is aware,
because of that, my lord.
31 ডাকবেন।
Because of that, my lord, going to adjudicate regarding the issue of the expiry panel. Here, in this repetition, my lord, because tainted list including experiment, it will be kind enough, my lord, give opportunity to address on that issue. What it will be, because before the apex court, my lord, it will be kind enough. Otherwise, my lord, If this
It's open.
Not today, but
It
whatever.
is,
not
it's
today, not
open.
today, not today.
It's open, you make your
Yes,
submission.
yes. Well, on 13, I because of the otherwise, I
Only,
want
only to digress, your lordship is aware for whom we are rising today.
Yes.
You know,
Very sad.
he is a very, it's a very sad.
Very sad.
You know,
Yeah.
he may, I am told he went for a, tooth, treatment, to a dentist, and he contracted, hepatitis C.
That's a very, very.
because of needles.
Tooth extraction. He went there, and he will not succumb to it. And he is a regular person. In your lordship, receive rank. Sudip Pal Chaudhary, unbelievable.
No, from
Ah.
dentist,
50 in and around.
hepatitis B and C.
See, তাই হয়েছিল
Call item 31.
I'm led by Mr. I'll led by Mr. Bhattacharya.
31 টা কি এইটা?
Item 31, what is it?
31 I'll led by Mr. Bhattacharya.
31, my lord. I am the petitioner. Kindly praying for 1 week's time, my lord.
Why?
Not for further research, my lord.
For the result?
For the further research, my lord.
Research?
31. Item
On
31.
last occasion, my lord.
অনামিকা রয়
But I appear for the state in this matter.
Kindly, my lord, fix it on 15th, my lord.
On the prayer of the learned advocate representing the petitioner to conduct further research on the issue. Release the matter for further consideration on 12th of February 2026. All right? Enough time?
My lord, if it is a little bit earlier,
Why?
interview is going on.
Yes, so you are not prepared. Matter is being adjourned on repeated
So
occasions.
much time is not required, my lord. 1 week's time, my lord.
1 week time?
15th, my lord. 15th or 16th.
19th of January.
19th of January.
Grateful, my lord.
8 and 11.
32.
32, my lord, this is the model answer question. My lord, 7 days time is required.
All right. Report filed.
I am
by the
appearing on
commission
behalf of state.
is taken on record. Stop. It will be open for the petitioner to file exception to the same within a week thereafter. Released on 16th of February.
But, my lord, this side, my lord, January, my lord, will it be recruitment process, my lord, it is going on.
Process is going on. Let us see.
My lord,
It's a long-
January, any day subject to convenience, your lordship.
I don't think, see, I have fixed matters and we have got vacations also in January, so it will be
27,
difficult.
28, end of January, my lord, because the
I
recruitment.
make it 27th.
27th January.
27.
Yes. Next is also same.
33 is the report there.
Same.
Same order.
27 January. Grateful to lords.
34.
34. আমি আছি the can that I filed
27.
They are not interested to proceed. And there is one more can 2 and pass an order. I do not want to proceed with that. And there is a new can 5. Kindly that allowed.
That you want to proceed. 1 and 2 you do not want.
Can 2.
Can 2?
Yes.
Can 2 is not there in the list.
Can 2 it is not in the list because it was already allowed.
Yes, then what remains? You do not want to
They
process.
say they given later they are not interested.
Correct. Leading to applicants in Can 2 has
They are now respondents 12 to 16. They may be their names may be expunged.
do not intend to contest the instant writ petition. Stop. The applicants were added as respondent numbers 12 to 16 in the writ petition. Stop. Let their names be deleted from the first title of the writ petition. Stop.
And there is a can 5. Kindly add me as parties.
3 and 4.
All must be selling in the same.
It is there. Can 4 will hear it.
Can 3 as well.
Can 3 will hear it. Can 5 is already there.
No, this order has to be passed.
All right.
Have to be added.
Can 5 please add.
Can 6.
Can 3 as well.
Can 6
Can 6 probably
is not there in the list.
similar petition was dismissed by your lordship.
Dismissed?
No.
Can 6 has not been enlisted. When did you file it?
Yesterday, my lord, not
That is the reason it is not there in the list. Let it come in the list, we'll see.
yes, yes, yes.
What is the matter about?
But this is a simple question, my lord, that the EWS certificate, if somebody did not possess on the last date of application, whether by mere making an application for EWS, they can be considered.
And whether the EWS certificate was there in the previous year?
Yes,
That
that is the.
That nobody knows, because this always it depends on the renewal.
Right.
Now the application advertisement says the people who do possess the certificate prior to X date are entitled to apply. But in the advertisement says who have applied for, they can also apply. That's the issue.
My lord,
All
here,
right, we'll decide it.
my lord, here, my lord,
And the division bench passed an order in the OBC or SC/ST?
No, that is in SC/ST.
SCSTP.
It was everyone, it was open.
SC/ST is a different concept.
No, no.
Yes,
that's
it's a different concept. Right. All right,
I'm told, my lord, this court was pleased to pass an order in WPA 24256, where the petition was dismissed because they wanted that anyone who have applied even thereafter be also considered.
There's
maybe I'll check up.
there was some direction for affidavit. Kindly extend the time. We'll file
In this matter?
সেটা করে নাও।
on instruction.
Readings ready করে নাও।
my lord,
I
can
think there was some direction.
But then kindly allow our application for addition.
That has been
Has it not been allowed?
No,
ঠিক আছে 3, 4, 5 allow.
my lord, 6, although already yesterday I filed it, not came in the today's list, my lord, yeah, yes, my lord, yes.
6 to be treated as on days list. ফাইলটা এসছে দেখে নিন তো treated as on days list করে allow করে দিন
No, 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 they are not the rate petitioner, they are free others petitioner.
and
No, no, no.
department will make necessary implement
Oh, I have
the
technical
first on the prayer of the no, not prayer. The time to file the affidavit in opposition by the respondents stands extended till how soon can you all come back?
Kindly give us 2 weeks, because I think
30th of January 2026. Reply if any within a fortnight thereafter. List 23rd of February.
Fortnight is 23rd of February.
No, no, interview is not yet completed. Tomorrow is also in.
They will supply the amended cost title.
Yes, amended cost title. All right. The department will make the necessary changes. Animesh Babu, department ke পাঠাবেন নামগুলো অ্যাড করা 3:15 মামলা
No other SLST map.